Oyez, oyez, all persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-5278, Cable News Network, Inc. versus Federal Bureau of Investigation Appellant. Mr. Poolham for the appellant, Mr. Tobin for the appellate.
Before we start, I'd just like to note that this is the first day and the first case that Judge Walker will hear as a member of the D.C. Circuit. We look forward to serving with him for many years. Because it is his first day, counsel, please go easy on him.
Thank you, Judge Garland.
Good morning, and may it please the court. Thomas Pullum for the FBI. I'd like to reserve 3 minutes for rebuttal, please. So the central question in this case is whether the common law provides a means of evading FOIA's carefully balanced scheme by offering access to statutorily protected information that is only before a court because of a FOIA lawsuit. It has long been accepted that when the government cannot fully justify its withholdings on public record, it may submit an ex parte declaration for the court's in-camera review. This procedure allows the government to defend itself without disclosing the very material it intends to keep secret. That purpose would be undermined and FOIA's balance upset if the common law could be used to compel disclosure of that information even when FOIA does not.
Mr. Pullman, haven't we already held in Metro Life that FOIA itself does not preempt the common law?
I don't think so. I think what was at issue in MetLife, as I understand it, was a more general argument that FOIA that FOIA wholesale displaces the common law. Here we have a more narrow argument that. And
in Leopold, we held that unless the statute expressly says that the information must be sealed, it doesn't preempt. So what section of FOIA says that ex parte filings are always sealed?
Well, I think there's two provisions to look at in FOIA. One is A4B, which provides for the in-camera review of the underlying documents.
It provides for it, but it doesn't say anything about it permanently staying that way. This is the problem we discussed in Leopold. That even where sealing is permitted, the question is whether the common law is displaced with respect to unsealing. What language, other than the permission of in-camera proceedings, are you relying on?
Well, I think the exemptions themselves and the fact that the district court has jurisdiction only to disclose information that's improperly withheld, which in turn depends on the application of the exemption. This court in Hayden said that requiring the district court to provide on public record information that is exempt, it said in that case that would violate Exemption 1. And that's why the court...
That was information that was held by the executive.
Well, in Hayden, it was specifically talking about the contents of an ex parte affidavit. And it said requiring the filing of that information on the public record would violate Exemption 1. This court has also kind of given broad effect to FOIA's exemptions with respect to a Glomar response, saying that this is what's needed to effectuate the exemptions. So I think it would not make sense or be compatible.
Well, the Glomar response simply says we're not able to confirm or deny. The Glomar response itself is not sealed. The Glomar response just permits the government to not reveal under FOIA if it's FOIA exempt. But the Glomar filing isn't itself forever sealed.
That's right, but I think what we're looking at is the access to information that is protected by statute. And I don't think it's consistent with FOIA to say, well,
what statute protects it?
The FOIA itself and also the National Security Act.
So if you lose on the proposition that FOIA itself protects it because merely providing for in-camera proceedings doesn't forever protect it, what aspect of the National Security Act protects it? The language of the National Security Act is an obligation for the Director of Central Intelligence or successors or related thereto. It doesn't say anything about the courts. And then Leopold, again, we said it has to say something about the courts. Same in MetLife.
Well, I'd like to get back to FOIA in a minute, but with respect to the National Security Act, the Supreme Court construed that statute in Sims, and it said that Congress had deliberately chosen to give control over the disclosure of information protected by that statute to the Director of National Intelligence, and had specifically chosen not to give courts the ability to compel disclosure. And it offered several reasons for that. One was that the government needs to be able to provide the most secure representation of confidentiality that it possibly could. And it said that compelled disclosure by a court could have a devastating impact on the ability of intelligence agencies to perform their duties.
Is this information classified?
No, this information is not classified.
Why isn't it classified? Information is classified under the executive order, zipping it down all the way to confidential if it harms in some degree the national security. Is the fact that you haven't classified this an acknowledgement that there's no injury to the national security?
No, not at all. And I don't. I think we can look at Sims to describe or to understand the harms that can be caused by the release of non-classified information relating to intelligence sources. None of the information issued in Sims was classified. The Supreme Court nevertheless said that the forced disclosure of an intelligence source could have a devastating impact on intelligence agencies. It said that even the risk that a court could order the disclosure of information relating to a source could deter sources from coming forward and providing information to the government.
So I have two questions about that. One, that sounds like an argument for why those redactions should not be unsealed, not an argument for why the declaration itself isn't a judicial record subject to the common law. That is, obviously the common law can be overturned and in individual situations by a strong interest of the government, which you express in the way that you just did. But I'm still interested, why isn't this classified? If the national security agencies are obligated to protect this, have they violated their obligation by not protecting it?
No, so the underlying information that this describes is classified. That was the purpose of the Archie Declaration, was to explain why certain redactions that had been made to one of the memoranda was classified. And it was classified on the basis of pertaining to intelligence sources. So the Archie Declaration described that information. It did so in terms that was not itself classified, but that information nevertheless relates to intelligence sources. And the Supreme Court explained why even innocuous information, when combined with kind of other pieces that a foreign intelligence entity might have, could lead a foreign entity to discover the identity of an intelligence source. And what the Supreme Court was doing in Sims was saying, this is an inquiry that just should not be undertaken by courts because they don't have the expertise necessary to identify which disclosures could be.
The specific question in Sims, I'm just going to read it to you, was whether the Freedom of Information Act requires the agency to disclose.
That's correct.
That was the question. It wasn't about the common law.
No, but the Supreme Court was explaining what Congress was doing through the statute, what the statute in fact did, and what it was intended to do. And that reasoning applies equally to disclosures under the common law as it would to disclosures under FOIA.
All right, I'll let my colleagues have a shot at it.
I just have a question. Is the Archie Declaration still in the possession of the court, or was it returned to DOJ?
I believe the court has a copy of it. To my knowledge, it was not returned, but I'm not 100% sure. That it was filed with the court, and I don't know that the declaration itself was returned.
If it were returned, would that affect the application of the common law for judicial access to judicial records application?
I don't think so. I don't think that necessarily turns on whether it's physically in the possession of the court or not. Many times exhibits or documents are given to a court for a time and then returned. Clerk's office does not always hold on to everything that might be considered a judicial record.
Okay. And then much of your argument, you fault the district court for not applying enough attention or given enough deference or respect to national security. But the district court said at a number of junctures in its decision that it was giving great weight to the asserted national security interests, but that the government just hadn't explained itself, couldn't explain why this was covered by the National Security Act, why it implicated intelligence sources and methods. And then in large part said that the reasons the Hubbard factors were struck against the government was because the government didn't even argue a lot of the factors. And hadn't given it any material to work with. So what are we supposed to do with an abuse of discretion review in that setting?
And with respect, I think the district court went wrong in a couple of ways here. It said it would give weight to the congressional judgment, but then it said that the government didn't do anything to address the strength of the interest at play. But the fact is that Congress had determined the strength of the interest at play through the statute.
But I mean, even under FOIA itself, Exemption 3, courts do have the authority to decide whether it's actually triggered by a particular document. And oftentimes the government will help us to understand that. But I don't think Exemption 3 has ever been interpreted to say all the government has to do is invoke it. And the court says, good, we're done. That's not your position, right? The court
no.
Okay,
no.
That's what the court here said. Look, I've looked, and you haven't told me what to do.
Well, I don't think the district court said it wasn't covered by the National Security Act. What it said is that it wasn't sure why secrecy was important here, and that's on JA 65. And that's the precise inquiry.
Well, what it said is it's not self-evident why secrecy is important, and that perhaps there's something here that is superficially innocuous to the untrained judicial eye, but if you piece it together with other things, it would be important. And then said the FBI, however, has provided no such rationale. And so the FBI hasn't given any basis for concluding that there's anything in here that actually merits protection. And in fact, never even invoked Exemption 7E, but not 3.
No, but it invoked specifically the National Security Act, which in the context of this case, the only relevance of that statute was as an Exemption 3 withholding statute. And the district court never took issue with the assertion that this information related to intelligence sources. And I think it's self-evident from the Archie Declaration itself, which, when explaining why this information is classified, redacts 2 categories of information that are embedded within discussions of a source of an intelligence source. Indeed, in paragraph 12,
it's self-evident, but the district court said in terms, nor is it self-evident.
It said it's not self-evident why secrecy is important. That's a different inquiry from whether information relates to an intelligence source. So there can be information that clearly relates to an intelligence source, as in paragraph 12 of the Archie Declaration, where it says, the revelation of the confidential source's name would identify the confidential sources redacted. That redaction clearly, I think, just from the face of it, relates to the confidential source. What the district court said is, I'm not sure why this information should be secret. But again, that's the inquiry that Sim said a court doesn't have the expertise to undertake, and it's distinct from the inquiry of whether information relates.
But you're saying anything that follows the end of that sentence is necessarily automatically going to be protected. Surely there are things that could follow that sentence that would not be, that could end that sentence, that would not implicate national security or intelligence sources and methods.
Well, again, the standard this court has set in Larson and other cases is whether it relates to an intelligence source, and the district court.
And that's what the district court said you haven't shown here, is how does this relate to an intelligence source or revealing information about a source or methods? I mean, the government does this all the time, and it was just sort of striking that the district court here at least said repeatedly, you've given me nothing to work with. And so the district court, as I read the opinion, felt like it was left with the choice of either simply taking the government at its word or doing some sort of independent judicial inquiry. And your view is it should have just taken the government at its word?
I think absent some kind of finding that the information did not relate to an intelligence source, that the district court should not have ordered it disclosed.
What do you mean relate to an intelligence source? If they said, we have intelligence sources, that relates to an intelligence source, but that would strike me as a completely innocuous statement without further help from the FBI.
Well, I mean, that doesn't relate to a specific intelligence source. This one is very...
Really, that's not the test. Is that your test?
Well, I just think that that's a totally different... It's just not what's presented.
It may be, we just don't know. That's the problem, right? You didn't...
Well, but, the district court had the document, I think, just on its... Again, I believe...
You've got a semicolon there, right? So it sounds like a whole new idea is coming.
Only in paragraph 11, but that's all in the context of things that relate to intelligence sources. I mean, the whole point of this paragraph is to explain why information redacted from one of the memoranda pertains.
Okay, so would identify the confidential source's job. Would job have to be protected? I know there's more words there, but would job have to be protected?
I think in some circumstances it might need to.
Exactly. The FBI would have to explain those circumstances.
In that case, I'm just not sure here that this falls in one of those cases. At a minimum, I mean, the district court committed other errors with respect to the Hubbard balancing test. For example, on the second factor, which deals with previous public access, it said that that factor was not in the government's favor because it had released other material. That gets matters exactly backwards. This factor asks whether previous access to the information at issue, it says that the court has said that provides a reason why it should be released in this context. But the public has never, nor had CNN as a FOIA litigant, had access to this specific information. On the first factor, the court acknowledged that there was little public interest in this specific information, which relates to an intelligence source. And I'd like to just underscore here the small amount of material that was withheld. We're talking kind of less than 5 lines. I believe it's around 40 words. The government disclosed all of its briefs are public. The other Archie declaration in full was disclosed. The ex parte proffer was disclosed in full.
So on that first and second factor, I mean, I take your point, but the district court found that you didn't even argue the first and second factors. Now you're making some interesting arguments, but what do I do with the fact that this is abuse of discretion review and you did not make those arguments below?
Well, this court has said that it is enough to put an issue before the Court of Appeals if the district court reached it. But that's a legal proposition, but in the course of abuse of discretion review of a particular decision, it's not whether we can consider it or not. It's just how can we say the court abused its discretion on the basis of arguments you tell us now that were not given to the district court? Well, because we can see what the district court did, and it committed errors in its reasoning. So we can't be sure that without those errors, it would have come to the same conclusion. And we can turn to other factors that there's no dispute that the government made arguments about. On the third factor, the court believes that FBI's objection shouldn't have the same strength as a third-party objection. And I don't think that makes sense with respect to information about intelligence sources that, kind of are important to the functioning of an intelligence agency. On the fifth factor, the possibility of prejudice, I think Sims kind of outlines the possibility for prejudice, which is that just the risk of disclosure by a court can cause a source, in the Supreme Court's words, to close up like a clam.
All right, Mr. Pullum, we're well over time. Do
Yes.
any other judges have further questions at this point?
Can I just ask one, Mr. Pullum? I think you may have forfeited at the district court your FOIA Exemption 3 argument, your argument that FOIA Exemption 3 should preempt the common law here. I also think that CNN may have forfeited at this appellate court their argument that you forfeited Exemption 3 at the district court. I'm going to ask CNN the same question, but if I think both those things, what am I supposed to do with that?
Well, a party certainly can forfeit a forfeiture argument. We think that the argument that whether the FOIA displaces the common law in this circumstance was sufficiently before the court, especially in the context of this case. And at a minimum, the court addressed that legal argument. As I was just saying to Judge Millett, it's a recognized exception to forfeiture that those general rules don't apply when the district court decides an issue. I think the district court did decide the issue, and we can bring it up here. But just looking at what was offered, I think the government had offered enough in the context of this litigation. It identified the relevant statute. It had made arguments that that statute was an Exemption 3 statute. With respect to the underlying information that Archie Declaration discussed, the government had asserted Exemption 3 over that information. And just given the way this case developed, where facts were constantly shifting on the ground, the Archie Declaration was submitted in response to an order from the district court to just provide a notice saying, if anything had changed on the redactions. The government released some information and provided the declaration to say, this is why the remaining stuff can't be released. So I think in these circumstances, especially to the extent the court has discretion to consider this, I would hope that it would exercise its discretion in a way to protect information that relates to intelligence sources that whose disclosure could cause some harm to that source. And that type of harm is outlined in the declarations that we provided, that sources can lose their utility or willingness to come forward. They may be retaliated against if they're uncovered.
Okay.
All right, we'll hear from Mr. Tobin. Thank you. Thank you, Mr. Paul.
Good morning, Your Honors, and may it please the Court. Your Honors, the questions of the government really expose the underlying issue here, and that's whether this Court should deviate from its unbroken line for the last 40 years, arguably the last 100 years since the in-rate drawback case, and hold that the government does not need to show all 6 factors under the now standard Hubbard test.
Could I ask you, I would like to pick up on what Mr. Pullum was arguing. So the standard of review, which is abuse of discretion, includes, according to our opinion in Leopold, if the district court misunderstood the application of the factors, that is, misunderstood the law, that we review de novo, correct?
The application of the law is a de novo review. That's correct.
So if we could go, I want to pick up on what Mr. Pullum was arguing here. I don't blame the district court for this because our cases have not been the clearest, and many of them have not presented these precise issues. But if you go through each of the judge's applications of the factors, I have difficulty with whether they're actually what the law should be. Leave aside the question of whether a law is completely clear on this or not. So the first factor that the judge applied is the need for public access. And the judge says, although the court sees little public value in the specific information that remains redacted, there is enormous public interest in the Comey memos. Now, it's my view, in light of what we said in Leopold about everything being particularized, the point of the Hubbard test is that we look at particular information to be sealed or unsealed. That the issue we should be looking at is, for each of the factors, is the information that was redacted, not some larger amount of information. Is that a unreasonable view of the law that I'm suggesting here?
Not entirely, Your Honor, but we also look at it as a process issue. The public interest could be colossal or it could be quite minute in the actual redacted information. Obviously, the more important the information, the more important the circumstances, the more that probably...
But you agree that we look at the information that is still redacted, and the judge says that that information he sees little value in. Now, if we're going to believe, I mean, you want us to take the judge's view that that there's not much injury to the national security, but don't we also, and I'll question that for a moment, but don't we also have to take the judge's view that there is little public value in the information that's still being withheld? If I'm really correct, all we're talking about is basically 2 full lines, maybe 2 1/4 out of the entire, of all the material that was once at issue. That's all that's left, right? Just those blacked out lines on page JA 146.
That's correct, Your Honor.
All right. So if I go to the next issue, which is the second factor, the judge weighs the extent of the previous public access to the documents. And here, there's been no public access to the redacted information. The judge focuses, again, I don't blame the judge for this, but I'm trying to, I think one value of this case is that we have some clarity here about the law. The judge says lots of, the FBI has already released the vast majority of the declaration. That's true, but that's not the issue. It seems to me that the issue here is the extent of previous public access to the redacted information. Isn't that right?
Your Honor, with respect, no. And if I could just make an extra point on part one, the need for public access is also a procedural issue. The judge made very clear that he relied on the Archie Declaration. He relied on all of it at several stages in the proceedings. There are 6 portions that we cited in the record where the judge relied on the Archie Declaration, or the government relied on the Archie Declaration to persuade the court to grant its summary judgment in the first summary judgment in the FOIA case. The public has a great need for access to understand the underpinnings of judicial decision-making.
Well, I understand. Obviously, I understand this, having written Leopold and MetLife. But the question here is, the judge basically is saying that he didn't rely on those 2 pieces of information because he didn't think they were important. So I'm not sure that's the right analysis. But even if you're right that that's the right analysis, the judge is saying, I'm not relying on this, on these lines. So I agree that
that's not how I read what he said was the added public interest. It may not be great in light of the rest of the declaration, but he didn't say that he didn't review it or rely on it. I mean, after all, he agreed with the government initially that the entire process was covered by a law enforcement exception 7A.
Okay. All of that, except for this part, has already been released. So let me move to the third factor. So that is, someone has objected to disclosure and the identity. And In Hubbard, this was a national children's, it's a different issue. Who else could object to disclosure of sources and methods other than the government? In the other cases, the concern was privacy of third parties who are concerned. Now, obviously, the sources and methods are not going to be coming to court and objecting. It seems to me that in a national security situation, the only party that really has relevant information about that is the government.
And granted, Your Honor, there is really nobody else who could stand in, and so there really is only, in that part of the test, there's only one party to look at. But when the government comes in and expresses its interest in an ex parte fashion, this is a case that had 8 declarations, an ex parte hearing that we didn't hear about until summary judgment was rendered, exhaustive briefing, in-camera review. When the government is the party, the court has an especially heightened duty, and I know Your Honor agrees with that, an especially heightened role in questioning the government and asking the questions. And our only point on factor 3 is that the court should consider in the common law balance that it has an enhanced duty to ask the government questions. And that's exactly what Judge Boasberg did. He repeatedly asked the government to establish why the information redacted from the Archie Declaration.
Again, I'm trying to pick at each one of the factors rather than the sort of zeitgeist of this. And this particular factor, the judge says that because it's not a third party, the government's argument doesn't have the same strength. But I don't see how that can be the rule in a case involving national security information.
Well, I think as I interpreted that, he was saying that I have a responsibility to conduct a very much more probing review if the government is a party. Not that the government's interest is diminished. It certainly is not. CNN does not argue the government.
He says it does not have, he ends up by saying, while the court takes the FBI's objection into account, it does not have the same strength as a third-party objection. And it strikes me as wrong, again, not the judge's fault, but wrong in a national security circumstance. Now, let me ask about the 4th and the 5th factors. I'm sorry, I got to get all the way to the 6th, so just bear with me. I'm going to combine the 4th and the 5th. So this is the question of intelligence sources and methods. And for this, what we have in the 6th Hardy Declaration is a statement that the information redacted on both pages reveals non-public information about intelligence methods. And that the FBI is obligated to protect such information under the National Security Act. So isn't that a statement both that information does reveal non-public information about intelligence sources, and because it has to be protected in the National Security Act, that it risks harm to the national security?
With respect, Your Honor, the first statement that the court said is correct. Of course, we take it at face value that the material is covered by the National Security Act. But the Hardy Declaration goes on to decline to answer parts 4 and 5 of the Hubbard test. It specifically says the FBI cannot provide any further details publicly about the still withheld information or the potential harms from disclosure. So the government expressly declined.
Because such disclosure would risk those harms occurring. The FBI is explaining why it can't publicly disclose it.
But it certainly had every opportunity, and the court invited it to, in numerous occasions, to present non-public explanations for it. Your Honor, we may not like, CNN it obviously stands for the proposition that the court should have maximum openness, that transparency serves the system. And I know the court agrees with that. That's what MetLife, Hubbard, and Leopold and League of Women Voters all stand for. But when it comes to issues of national security, the solution is not for the court to stop asking questions. The court should always be asking questions under the common law. And the government certainly had opportunities in this case to answer those questions in whatever fashion it needed to safeguard whatever interest. The judge, I will say Judge Boasberg was very receptive, and there are notations citations on J42, 46, 53, 54, 56, 64 to his role. He appreciated his role in the sensitivity of national security information. But what he said when he accepted the government's rationale under Exemption 1 for a bunch of the redactions and under Exemption 3 for a few of them is that the government provided a plausible rationale tailored to this factual circumstance. The Hardy Declaration expressly declines to do that. The Hardy Declaration is the only place that the government has pointed to where it has met that obligation, and so it has not satisfied its burden.
Let me ask about the sixth factor. So for that one, the purposes for which the documents were introduced, and the quotation is, the public's entitlement to judicial records is commensurate with the document's importance to the judicial proceeding in question. Now, the issue in this as being the single most important factor, the judge said this is the single most important factor. I totally agree that this is a relevant factor, but the idea that it's the single most important factor, the problem in Hubbard is, from the quotation is, it was the single most important factor in Hubbard, but Hubbard wasn't saying it was the single most important factor in the test. And the reason it was the single most important factor in Hubbard was sort of the opposite of the argument in this case. It was an explanation for why the information in the search warrant should be kept secret by a third party was making that argument. I think it was a Scientologist. And the reason it was the single most important factor there was that filing would have disclosed the very information they were trying to keep secret. That's really the same argument here. So I'm concerned that the court saw those words, the single most important factor, and said it was, when Hubbard didn't mean that to apply across the board. And even in Hubbard, the way in which it was applied would apply in the opposite way that it was applied in this case.
Well, Your Honor, whether it's the single most important factor or just a factor, the fact is that the district court relied on the Archie Declaration. The government asked the district court in seeking leave at ECF 23 to file the Archie Declaration ex parte. It asked to aid the court in the resolution of the exemption claims by filing the Archie Declaration. We filed last week, Your Honor, a supplemental joint appendix. It's the transcript of the ex parte hearing that the court held. The court opened up the hearing by saying, I have reviewed the Archie Declaration and I need your help. I need further help. And by the way, that is an instance where the government provided the help, the linkage the judge needed to get over the hurdle, the hump of the argument that they were making. They were quite capable of making that argument, Your Honor. And so, there are other parts, ECF 49, the district court in the original summary judgment ruling relies on the Archie Declaration of 3 points. And Judge Boasberg left no doubt in this ruling that at J 6263, he relied on the Archie Declaration as a fundamental document that influenced his judicial decision making. And that's where we read the argument to lie in Part 6. I might also mention, Your Honor.
Let me let my colleagues have a chance. I've
please.
Taken up all the time.
Thank you.
I apologize.
I'll jump in. It seems like the thrust of your argument for a lot of the factors that Judge Garland was going through is that the government should lose because it wasn't specific enough in explaining why the redacted lines should stay redacted. My worry is if they had been more specific through an ex parte in-camera declaration that provided more specifics, you'd be asking for that now. You'd be asking us to unredact their explanation of why they shouldn't unredact what's now redacted. What do I do with that concern?
Your Honor, I can't say that we wouldn't. I think it's something that the court has to take argument by argument by argument. There is certainly a lot of litigation. CNN is involved in a lot of it in the district court, trying to unseal court records. That is not an appropriate part of the process. It would give Judge Boasberg and the other district court judges the information that they need to make the determination, however, that if that ex parte filing justifies the sealing of the Archie memorandum in this case, then in all likelihood, we would not be able to prevail either under the common law or would be alternatively argued in this case the First Amendment access standard. And the court would have the information that it needs to weigh. And so, Your Honor, that is not an unlikely scenario, but it is not an inappropriate one either. And it would give the district court every tool it needs to make the right decision.
Well, it might explain why the FBI here was not more specific. They may have thought, well, if we're more specific, that will stay redacted under the six-factor Hubbard test. But, you know, six-factor tests are not the most predictable tests, and we don't know what judge will get. We don't know what panel will get. And if it were to go en banc, we don't know what the en banc. We just don't know exactly what will happen. So we're going to err on the side of not being specific in case that eventually gets unredacted. But since we're low on time, let me ask you the same forfeiture question that I asked the FBI. Assume I think they forfeited their Exemption 3 argument in the district court. You didn't make that argument in your appellate brief that they forfeited their Exemption 3 argument in the district court. So does that mean that you have forfeited your argument here, that they forfeited their argument there?
Well, we have to go back one more level deep, Your Honor. The Exemption 3 argument was raised on the Rule 59E motion. The 59E motion was denied. The judge said that they had their opportunity and they waived the argument on summary judgment. They also did not appeal. They appealed. They listed it as an item in the notice of appeal, but they did not brief any error in the Rule 59E argument. And so I think the waiver balance, if that's how the court is looking, weighs heavily against the government as to whether the Exemption 3 argument is live in this court. Your Honor, if I may also just go back very briefly to your previous question, Judge Garland, may I just add a couple more sentences?
Yes, but I want to let's see if Judge Millett has any questions, and then you can do that at the end.
Okay, well, I'm happy to have him answer yours first if that's easier.
Okay, go ahead.
Go ahead.
Mr. Tobin, go ahead.
Just to Judge Walker's point, Your Honor, you know, in our view, the FBI has a solemn duty to make its arguments to this court in as narrow a fashion to allow public access to judicial proceedings and under FOIA public access to agency records. We would hope that the FBI would use every reflection and introspection in presenting affidavits to the court and in presenting ex parte arguments. And so if there is a chilling effect on the FBI, if they are worried about exposure of ex parte information because CNN or Fox or anybody else comes in and asks for public records, I would argue that it's a healthy part of the process, that there is a common law test that this court has fundamentally and rigidly applied for the last 40 years, and that would have a healthy impact on the process. And I have every confidence in Judge Boasberg and the other courts in this district that they will reach the right accommodation when they see the information presented to them.
All right. I wanted to ask, let's talk about let's just assume that you filed a FOIA request for the Archie Declaration, not a common law access. And the district court, it's a whole new case, and the district court looks at the Archie Declaration in camera to try to figure out if Exemption 3 or 7E really applies. If they do apply, you agree you couldn't get the declaration under FOIA, correct?
If it meets the standard under FOIA for the exemption, yes.
The 3 and 7E. Could you still argue that in-camera submission, I'm not talking about the affidavit, I'm talking about the actual in-camera submission, you could still obtain it, even though you couldn't get it under FOIA, you could still obtain it under the common law right of access, as long as the factors broke in your direction?
Well, Your Honor, nobody appealed the FOIA document.
I'm asking a hypothetical here, and that is, can you obtain under the common law access right of access to judicial records, anything that isn't available under FOIA, just because it was submitted or in camera?
Your Honor, I think there are two ways the court could go. My preferred route would be to follow the common law analysis, and if it broke in the government's favor on factors 4 or 5 or any of the others, then no, we could not obtain them. The other way that the court could go is to say that, as in the FEC case, I think it was In Re Sealed case, the only reason the document is being filed with the court is to see if it should be sealed or unsealed. And under that case, it is not subject to the Hubbard factors. Although
I'm not sure what I guess I'm not quite understanding your argument. I don't want you to tell me what the court could do. I'd like to know what CNN's position is. And is it that as soon as that document is filed in camera on a FOIA case, a complaint could be amended to say we'd also like to now get that in camera filing under the common law right of access, and which you could do. You could amend the complaint to say that. I don't think there's any dispute about that. And the question is there any case that you can imagine in which the answer to the FOIA question and the common law access question would be different?
Your Honor, CNN believes that any document filed in a court should be analyzed under both the Hubbard test and the First Amendment. So yes, it would be subject to challenge. Your Honor.
Isn't this exactly the question that was addressed in MetLife? Mr. Tobin, in MetLife, the argument was made that the right to the information, that they could seek the right to information through FOIA negated any right to receive it under the common law. And the court held that FOIA only applies to documents in the executive's hands. And once the executive puts them into a court filing, which is what happened in that case, it's not, to the extent the court has control over the document, it's not controlled by the Freedom of Information Act. It's controlled by the court, assuming it's a...
That's exactly right, Your Honor.
Yeah.
The answer is yes, it could be released.
I didn't make that clear. I apologize, but that's exactly right.
All right, so your position is that the in-camera document itself could be released under judicial common law access standards, even if it would be withheld under FOIA.
Under the ruling in MetLife,
in camera filing, right? Doesn't that seem? MetLife didn't involve an in-camera filing. In-camera is this very, unique procedure that we have for the resolution of FOIA cases. And I'm trying to figure out if your legal position is that as soon as you invoke that process that FOIA allows for in-camera filings, then immediately that document suddenly becomes available under the district court surely couldn't order the government to release it unless it found no FOIA exemption. But if it found a FOIA exemption, it can't order the agency to release it. But the court could release it itself.
Well, in MetLife, Your Honor, the documents were filed in camera under Dodd-Frank in a sealed appendix and sealed brief. And in that case, as Judge Garland said,
a sealed brief isn't the same thing as when parties seal filings all the time, right? But a formal in-camera proceeding is not the same thing as a sealed document.
But that's what happened in the district court in the MetLife case, that the documents were reviewed in camera. And then on appeal, the party argued that it was subject, or actually in a motion for access, and then on appeal, that it was subject to the common law test. And Judge Garland and the other judges on
there are findings there that it could not be released under the FOIA provisions.
I'm sorry, Your Honor?
There are findings there because the Dodd-Frank there sort of incorporated the FOIA process and exemptions. And so was there a finding there that it would not be it would be forbidden to be released by the agency under FOIA, but it could be released by the court?
There was not that specific finding.
That's what I'm asking about. Okay. All righty. Would you agree if the information in the Archie Declaration were in fact protected by Exemption 3, the court should not release it, or it still could under the 6 factors?
I think, Your Honor, that the FOIA, the finding under FOIA does not answer the Hubbard test completely.
I'm just talking about exemption 3 here. I'm not talking about all the other exemptions under FOIA, which, you know, there's a lot of those. I'm talking about exemption 3, and to be clear, of course, national security protection under exemption 3. There's a lot of exemption 3 statutes. But.
No, I think you could read Judge Boasberg's opinion to say that he assumed it fell under exemption 3, but even arguendo.
Your position is even if it's protected by the National Security Act, could not be released under FOIA under exemption 3. It can be released under the balance. Put aside the forfeiture issues. It can be released under the balancing test.
That's the command of the MetLife test. Yes, Your Honor, that is our position.
Okay, thank you.
All right, I know we're out of time on a rebuttal. If that's more our fault than Mr. Pullum's. So if you want to take 2 minutes, go right ahead.
I'd like to make just a few points very quickly. I think Judge Millett has gotten to a key problem with CNN's position here. And I think that El Sayegh, this court's case in El Sayegh, indicates that when a document is before the court solely for the purpose of determining whether it should be released, that the common law doesn't apply. And the consequences of CNN's position would totally undermine FOIA. We would have, it doesn't take much difficulty to imagine situations where there would be FOIA requests for all kinds of documents. The requester would say, district court, please examine them in camera to be sure. And anytime that did, the document could be released under the common law under totally different standards than what FOIA provides. The second point I'd like to make is CNN hasn't argued that the district court mistakenly accepted the ex parte declaration for in-camera review. So there's a real disconnect here between saying the FOIA litigant can't have access to this information, but after the case is resolved, a member of the public could come in and get it. I think that's a real problem with their position. And the third point I'd like to make. All
right, I just don't understand that point, because the FOIA litigant is also a member of the public and could always assert common law access rights.
Right, but I think it's odd to think that you can litigate the FOIA case and the requester can't have access to information for the purpose of kind of a statutory claim, but then later you can apply totally different factors to release it to, someone else. That seems to be not an ideal situation. And the final point I'd like to make is CNN acknowledged that that it didn't dispute that this information was covered by the National Security Act, and I think that should weigh very, very heavily in these 4, 5, and 6 factors. This court said in the Henry Sealed case that where Congress passes a statute restricting an agency's ability to put information on the public record, that rarely, if ever, should the Hubbard factors overcome that. The district court here said that because the government's investigation was at an end, so too is the strength of the Bureau's argument. But coverage under the National Security Act, which relates to intelligence sources, doesn't depend on the existence of an ongoing investigation. All sources are protected, whether there's a current investigation or not. So for those reasons...
Can I ask you a question? Because before the district court, the government did invoke 7E to protect law enforcement confidential sources. But now we're not hearing about 7E, we're told about the National Security Act and Exemption 3. Is every FBI confidential source covered by 7E also an intelligence source covered by the NSA? Or why wouldn't, if not, then why, how do we make that jump?
Well, the National Security Act specifically relates to intelligence sources, and I believe 7E relates to confidential sources in an investigation. So you could have a source in an investigation that has nothing to do with intelligence. It could be someone, saw someone on the street breaking into a car, someone's in a drug organization. That could be a confidential source without being an intelligence source or relating to an intelligence method. So I think those are...
I'm just trying to understand how we got from the government, wasn't presumably was thoughtful in all of its filings, and it was explicit about this is a 7E confidential source for law enforcement. And it wasn't until Rule 59 in here that we suddenly heard that the same confidential law enforcement source or method that's supposedly at risk here is also an Exemption 3 one. It just strikes me as quite hard to believe that the government wouldn't have noticed when it invoked 7E whether that person was also an NSA intelligence source or method.
So just to be clear, the Archie Declaration was describing information that was withheld under B1 as being classified pertaining to an intelligence source. So it was clear from the very beginning that that was an intelligence source material. The government also...
Where was this clear that it was an intelligence source?
So
references to 7E.
If we look in
the Hardy Declaration.
In the Hardy Declaration, in the Archie Declaration itself, this is on page JA 146. These redactions come from a section discussing why material in one of the Comey memos that was not requested by CNN, was requested by another party and then dropped out of the litigation. Archie is describing why this information is classified under section 1.4C of the executive order. That same underlying information in the Comey memo, the government asserted Exemption 3. This was in the first round of summary judgment briefing before it came up to this court and was remanded. So that the underlying information was flagged as relating to an intelligence source.
And hang on, this is, I'm because an Exemption 1 classified information is of an even higher caliber than an Exemption 3 NSA, and you're not claiming that the Archie Declaration information at issue here, if I heard you right in your response to Judge Garland, you're not claiming that this is classified information or an Exemption 1 eligible. And so the only jump I'm seeing is from the Hardy Declaration invoking 7E for this source methods information to Exemption 3. And now you're throwing Exemption 1 on the table, which is making things more confusing for me.
I'm sorry, so I'll walk through kind of step by step. Initially, in the first round of this litigation, one of the documents at issue one of the Comey memos at issue had information that was classified relating to an intelligence
Right, I understand
source.
that. And
okay.
that's not one that CNN thought. Are you
right.
saying that this Archie, I'm sorry, just because we're short on time, that this portion of the Archie Declaration is speaking to the Exemption 1 information in the Comey memo?
It is. You can see on the heading on JA 146.
Exemption 1 information.
That's right. It's describing why the underlying information is Exemption 1, and it's doing that using information that would be protected by Exemption.
Why did Hardy talk about 7E and not 3?
So just to move on to the next step, if I could. So after the Archie Declaration was filed, or with the at the same time, rather, the government moved for summary judgment with respect to this memo that CNN didn't request.
Right.
And the government said this is protected by B1, and then there was a separate section of its summary judgment. I believe this is docket entry 22 or something around that. There's a separate entry that says this material is also covered by Exemption 3 because it relates to intelligence sources. And it's often the case that something that's covered by B1 under Section 1.4C will also be B3 because they both relate to intelligence sources. So that was the first round. So we had already established that the underlying information is B3. Then we have the six-party declaration, which says that the information in the Archie Declaration is covered by the National Security Act. And it had already been litigated in this case that the National Security Act was a B3 exemption statute. Mm-hmm. So that's the connection. It wasn't just that it was a law enforcement source. There's been an ongoing claim this underlying information relates to an intelligence source as well.
Okay.
I hope that was a little more clear. I apologize.
Thank you.
So for those reasons, we ask that the judgment be reversed.
All right, thank you all very much. And I think Judge Walker did an excellent job on his first outing. We'll take the matter under submission, and the clerk can call the next case. Thank you all.
Thank you.
Case number 16-1430, Truck Trailer Manufacturers Association, Inc., petitioner versus Environmental Protection Agency et al. Ms. Theodore for the petitioner, Mr. Byron for the respondents, Ms. Henderson for the respondent interveners.
Theodore.
Good morning. Elizabeth Theodore on behalf of petitioner Truck Trailer Manufacturers Association. I'd like to reserve 5 minutes for rebuttal, and I'll start with the EPA regulations and then turn to NHTSA. So the Clean Air Act speaks directly to the question whether the EPA can regulate trailers, and makes clear that it cannot. Section 7521 authorizes the EPA to regulate motor vehicles, and Section 7550 defines a motor vehicle as a self-propelled vehicle designed for transporting persons or property on a street or highway. And since trailers are not self-propelled, that is game over for the EPA. And if the court had a chance to look at the 28J letter that we filed yesterday, the IRS just reached the exact opposite conclusion from the EPA and said that that same language unambiguously excludes trailers. So one of these two rules violates the APA and is clearly the EPA's rule. The self-propelled limitation also precludes EPA's theory that it can regulate trailers as part of a quote-unquote tractor-trailer vehicle. Trailers are the only thing designed to transport people or property on the road or highway that is pulled by something else. And the term self-propelled had to have been designed to exclude trailers. EPA doesn't dispute this and has no alternative explanation for this language. And that text would be completely meaningless and ineffective if the EPA could just regulate trailers on the ground that they're pulled by tractors and tractors are self-propelled. Congress obviously knew that trailers were hooked up to self-propelled vehicles when it chose to exclude them. The tractor-trailer theory fails for multiple other reasons. There's no such thing as a unitary tractor-trailer vehicle. And trailers are never permanently married to each other. They're separately regulated under federal law. They have separate vehicle identification numbers under federal law. Many shippers own 6 trailers per tractor.
Why do they have to be permanently married, as you said? You know, the question is, what is their status on roads and highways? And on roads and highways, when they're traveling on roads and highways, they are a single unit. That's how they transport property.
So there's no one tractor and one trailer that's a single unit. And I mean, the proof is in the pudding. So the EPA claims.
But I'm asking why you were sort of, there's not one as in permanence, but maybe there's one somewhere in the country that I don't know of. But if there were, would that count? If there were actually someone who owned both a tractor and a trailer and at least, rented his service for her services out for moving stuff, would that vehicle then, the trailer and tractor combined, count?
That still would not be a motor vehicle under.
It doesn't matter whether it's permanent or not in your view. But then why isn't it when it's on the road together? That's what the statute is looking at, is on the road and on the highway for the EPA, on the road and on the highway. And that's how they function together. If I'm driving by a semi-truck, I don't think I'm going just by the tractor. I'm going by the combination of the two. And if I feel like I'm hit by a semi-truck, it's going to be the two of them together that's going to be causing the terrible harm to me. And my understanding is that when you get to weigh stations, they weigh it together as a single unitary. I mean, that's what the gross vehicle weight at a weigh station measures, is the single unitary weight of the tractor and its trailer and contents together.
Well, so in the context of the Clean Air Act, it's very clear that the motor vehicle can't be the joint tractor and trailer. And And just look at the rule itself.
I think very clear. It's not so very
and I'll
clear.
explain. So there's not a single aspect of this rule that actually regulates a joined tractor and trailer. And that's because it's impossible under the statute. So just one example is the certificate of conformity requirement in section 7522. That requires a certificate of conformity for a motor vehicle before it's sold. But you can't get a certificate of conformity for a joined tractor trailer because they're always sold separately, and that's uncontested. So that provision would be impossible to apply if the quote-unquote regulable motor vehicle was the tractor trailer. And the regulation, in fact, requires a separate certificate of conformity for the tractor and for the trailer. It's not treating them as a single motor vehicle. And similarly, so the EPA can only regulate vehicle manufacturers under the statute. That's also uncontested. Trailer manufacturers don't manufacture tractor trailers. They only manufacture the trailer. And just in this, so the government relies on this engaged in language. But, no one would say that Goodyear Tire Company is engaged in manufacturing vehicles just because it makes tires and tires goes on vehicles. And similarly, the warranty provisions in section 7541 are incoherent if the vehicle is a tractor trailer. So that provision requires the manufacturer to warrant the motor vehicle to the so-called ultimate purchaser before it's sold. And first of all, there is no ultimate purchaser of a tractor trailer because, again, they're always sold separately. And second of all, EPA's theory would mean that the trailer manufacturer has to warrant that the entire tractor trailer complies, which is impossible because the trailer manufacturer has nothing to do with the tractor. And EPA theory also, so it says that it can regulate trailers as like a quote-unquote integral component of a tractor trailer. That makes the Clean Air Act's authorization of motor vehicle engines and engine manufacturers utterly superfluous, since engines are obviously an integral component of a vehicle. And so for all of those reasons, but again, I would return just to the use of the word self-propelled in the statute, which is obviously intended to exclude trailers. EPA has no authority to regulate.
Why isn't the tractor, for all intents and purposes, the engine that gets attached to the trailer and then makes the trailer move? Right, that's really what the function of the tractor is to haul the trailer around, to make the trailer mobile and able to be moved to different places.
Perhaps, but that doesn't make the trailer self-propelled. It means the trailer is propelled by something else. And
the statute does talk about regulating, both engines and vehicles. That both can be regulated.
Yes.
So it suggests to me that there's some regulation of vehicles that's distinct from regulation of an engine.
So I think the goal of the separate authorization to regulate engines or vehicles authorizes EPA to regulate engine manufacturers separately so that they don't just have to apply regulations to engines in the context of regulating the motor vehicle after the engine has been incorporated. I think that's the real goal there.
But why isn't this the incorporation when it becomes a tractor trailer? Why isn't that the incorporation of the engine into the vehicle?
So I think if the EPA wanted to regulate, a motor carrier that assembles a tractor to a trailer, maybe they could do that, but they certainly can't regulate the trailer manufacturer.
So the statute says manufacturing or assembling of a new motor vehicle. So when you say maybe, it seems like it's not a maybe. It definitely could regulate an assembler. Isn't that right?
It definitely can regulate an assembler. I think there's a question whether putting the trailer to the tractor creates a motor vehicle for all the reasons I explained, that like the certificate of conformity and warranty requirements.
Yeah, that's with respect to this regulation. Just to be hypothetical for a moment and picking up on Judge Millett's questions. So the term motor vehicle means any self-propelled vehicle designed for transporting persons or property on a street or highway. When it's assembled, it is self-propelled and it's designed for transportation on a highway. So that would seem to be able to regulate assemblers and require an assembler to only assemble a vehicle that meets the emission standards as an assembled vehicle.
Potentially. And as we said in the regulatory comments, if EPA's theory that a tractor trailer is a motor vehicle under the statute has any legs, then the only thing they could do would regulate the assemblers. But there's no dispute that the trailer manufacturers, which is who is being regulated in this regulation, are not manufacturers and are not assemblers. And let me turn.
Could I ask? Sorry, I don't want to keep you from getting to what you want to get to, but could EPA pass a regulation that says tractors are banned, these types of tractors are banned from traveling on roads and highways if they're pulling loads that cause the tractor's emissions to increase by XX amount, and that XX is some fancy computation of sort of on average how much trailers cause tractor emissions to increase.
Possibly, and
it could do this. It could do that, which it could do that, right? I don't see why it couldn't. That's a direct regulation of tractors and their emissions.
I think probably yes, and the current.
But isn't that getting to the? I'm sorry. Go ahead. Finish.
The current tractor regulations do sort of assume a hypothetical trailer load as well, but it's not the same thing as regulating trailer manufacturers.
But wouldn't that be? I guess it seems like you're saying that they can do indirectly. They can't do directly what they can do indirectly, because if they were to pass something that said no tractors can go on the road if their emissions are up at the level they would be if a trailer were attached, everyone knows what's going to happen. Every trailer manufacturer is going to have to put on some of the things here, the aerodynamic curtains and backing and the tires and everything to get themselves under that limit. Otherwise, no one's going to be able to pull their trailers.
Well, so the members of the TTMA are actually totally fine with attaching equipment that their customers demand. But, it does make a difference who a regulation regulates, right? So motor vehicle manufacturers, like they're billion-dollar organizations. Trailer manufacturers, the overwhelming majority are small businesses. And this regulation imposes huge compliance costs. And Congress didn't intend for trailer manufacturers to bear those costs, and it's clear that it didn't because it used the word self-propelled. Let me turn to the NHTSA rules. So the EPA's clear lack of statutory authority means that the court should vacate the entire portion of the rule because NHTSA's rules are non-severable from EPA's. And under the broadcaster's case, a rule is non-severable if the agency didn't intend severability or if the remainder of the regulation couldn't function sensibly without the stricken provision. Similarly, the Supreme Court said in Kmart that it's non-severable if striking the invalid parts would impair the function of the regulation as a whole.
Have those rules ever been applied when you're dealing not with a single set of regulations, but separate regulations issued by two different agencies? Is severability even the analysis to determine whether those regulatory schemes function?
Yes, Your Honor, for a couple of reasons. First of all, all of this court's discussion and the Supreme Court's discussion of the rule is it takes the text, which is the rule, and looks at each part. But more specifically in the Delta case, which is this court's case, the court did essentially apply a severability analysis to a joint EPA NHTSA rule, and it said that they were severable because in that case, NHTSA's rules weren't dependent on EPA's, and that's just a severability analysis. So
you want them to be not severable, right?
I'm sorry?
I thought you wanted them to be not severable, and in Delta they were severable.
In Delta, they were severable, and Delta is just an example of the court applying the severability analysis in the same way to a joint agency rule. Here, of course, the NHTSA rules are very clearly dependent on the EPA's rules. And so
can you elaborate on that a little bit? Because I took your reply brief to focus in particular on three aspects of the regulation that would not work if you took the EPA out of it. And hopefully I can remember all three right here. One was the compliance certificate of conformity. Only EPA can issue that. Another was the setting of the standards. Under the regulations, EPA sets the standards. And then the third was the testing. So to see whether or not a particular trailer would satisfy the standards that EPA sets, the regulation imagines that the EPA will do the testing. The government says that will all basically work even if you take EPA out of the equation. Can you go through each of those three and explain why you think that's wrong?
Sure. And let me start with the certificate of conformity. So there's no dispute that the EPA is not issuing certificates of conformity because this court stated its rules and held that it doesn't have authority to regulate trailers. And the NHTSA standards, in particular section 535.10, state that manufacturers may not introduce vehicles into commerce without a certificate of conformity from EPA, and that manufacturers not completing these steps do not comply with the NHTSA fuel consumption standards. And you obviously can't.
The government, I'm sorry to interrupt, but the government says we just scratched that part out. So now the trailer manufacturers don't ever have to get a certificate of conformity. Problem solved.
Right. So, and there's sort of two responses to that, Your Honor. The first is that's not the way severability analysis works, right? The question isn't could the rules be rewritten in a way that would allow them to function. The question is whether the rules as written can function without the stricken provisions, and that's very clear. And second, you can't strike the certificate of conformity requirement. I mean, it's the core part, it's a core regulatory requirement, and it's the only way that trailer manufacturers can even be assured that their vehicles are, in fact, compliant with the substantive standards. So, I mean, you can ask the government, but I just don't know how the regulation could possibly function.
On the other two, the setting of the standards and the testing, couldn't EPA just continue to set standards that on their own do not have force of law, but NHTSA could take the standards that EPA sets and apply them to trailers with the force of law? And same with the testing. EPA could still do the testing. You wouldn't get fined by EPA if you violate EPA's test, but you would get fined by NHTSA.
So I don't think so, Your Honor, and I'll provide the same response, which is that the regulations as written just don't make any sense. They can't function if you strike the EPA regulations because they would be cross-references to nothing, to invalid provisions. But also, EPA can't regulate without congressional authority. I mean, NHTSA can't outsource its authority to another agency without congressional authority to do that. And look, I mean, the agencies don't even really believe what they're saying because the fact of the matter is EPA is not conducting the testing right now. It's not issuing certificates of conformity, and that's because this court said it didn't have authority to do so.
One last question, Ms. Theodore. Do you have a sense of what this costs, this regulation of trailers?
For the trailer manufacturers?
For the economy, yeah, for the trailer manufacturers.
You know, I don't know for the economy, but for the trailer manufacturers, you know, it depends on the manufacturer, but for some of them, the compliance will cost millions of dollars. And again, these are small businesses. This is a big deal for them.
But I mean, nationwide, do you have a sense, are we talking about a $1 billion impact on the industry, more than $1 billion? It's okay if you don't know. I'll ask the government the same question.
Yeah, I don't know the answer to that. Okay, so I think the NHTSA rules are way more intertwined than other rules that this court has held non-severable before, and I don't think this is really subject to reasonable dispute. There's no way that NHTSA would have adopted this exact same regulation, cross-referencing EPA's rules 400 times. If EPA...
Can I ask, is that the question? Is the question about function question of NHTSA's intent, or just a question of whether it's arbitrary and capricious if we sever a part and leave the rest? I mean, the intent is clear. They've said what their intent is. We want it to stand alone. It could still be arbitrary and capricious, and that I think is what the function test goes to. I don't see, or in a circumstance where the agency hasn't told us what their intent is, then of course you would look at it. Do you think that's the right kind of analysis?
I think the function test is independent of the intent test, and that's what the court said in Broadcasters.
Independent because what are we relying on for it? Now, what authorizes the court to make a function test? Is it the arbitrary and capricious standard?
I don't think so, because I mean it applies to the same analysis applies to statutes as well.
But in the case that you cite, there it's used to determine intent where intent isn't clear. I'm asking you, I mean, where would we get the authority to simply say that this doesn't function unless it's because it's arbitrary and capricious without the other part of it?
I mean, I suppose you could say that. I don't know, but it's clear the court does have the authority because I mean the Supreme Court has the Kmart decision, which says that the question is whether striking one part of the regulation would impair the function of the regulation as a whole. So it may be.
Can you remind me, in that case, did Congress express its intent? In
the Kmart case?
Yeah.
It was a regulatory case.
Okay, then in that case, the express.
I'm not sure, but I can tell you that in the broadcaster's case from this court, the agency did have a severability clause and nonetheless held that the regulations were non-severable because they couldn't function independently.
Which sounds like because they were arbitrary and capricious. It wouldn't
Perhaps,
make
Your
sense
Honor.
to have a rule that doesn't function.
And I think that makes a lot of sense as the explanation for the analysis.
Okay, thank you.
So let me turn quickly to the NHTSA question. Even if the rules were severable, NHTSA lacks authority to regulate the quote-unquote fuel economy of trailers. And that's because trailers don't have fuel economy under the definition in the ESA. NHTSA agrees that trailers don't consume fuel, and so the standards that are being issued here are not fuel economy standards within that definition. And second, trailers aren't vehicles within the meaning of ESA either. Vehicle in this context clearly means fuel-consuming vehicles. That's what all the other vehicles in the list are. And Section 108 of the ESA refers interchangeably to this category of vehicles as trucks, which under the statute and under NHTSA's longstanding regulatory definition does not include trailers. And I'd like to reserve the remainder of my.
Can I ask the NHTSA's Organic Act says a motor vehicle means a vehicle driven or drawn by mechanical power. So if you were looking anywhere for the closest definition, you would look at the agency's own statute, and this is clearly a vehicle driven by or drawn by mechanical power. In fact, it is a vehicle drawn by mechanical power.
Well, Congress did not, of course, incorporate those provisions into the ESA. Did not incorporate that definition.
That's true, but they also didn't incorporate the EPA's definition of vehicle.
That's true, and we're not relying on the EPA's definition to analyze the meaning of vehicle in the ESA, but there are a number of other textual clues, including the statute's focus on fuel, the definition of fuel economy, the fact that the statute refers interchangeably to trucks when it's describing this category of vehicle, and trucks, of course, are vehicles that have motive power. The fact that the one provision of the ESA which refers to trailers also distinguishes between trailers and trucks. And the fact, so I mean, all of those are very strong textual clues that what Congress meant here did not include trailers.
All right, further questions from the bench? If not, we'll go to Mr. Byron.
Thank you, Judge Garland. May it please the Court. Thomas Byron from the Department of Justice here on behalf of the federal government agencies. Both NHTSA and EPA independently exercised their authority under their respective statutes and interpreted ambiguities in those statutes to permit the agencies to regulate tractor trailers as the relevant vehicles subject to fuel efficiency and greenhouse gas emissions regulations. The statutes themselves do not address, Congress, that is to say, did not specifically preclude the agencies from regulating tractor trailers as motor vehicles in this way. So this question comes down to step 2 of Chevron and the reasonableness of each agency's explanation for its statutory interpretation. And here the agencies...
Mr. Byron, NHTSA just recently, I'm going to try to find this, issued a regulation in 2020 that it talks about a vehicle and a trailer attached to the vehicle. And that it's cited in the manufacturer's brief. It's from April 30th, 2020. If NHTSA itself talks about a trailer as recently as this year as not being a vehicle, but rather being something that is attached to a vehicle, what do I do with that?
Judge Walker, I think you're referring to what the agencies call the SAFE rule, which is
that's right
under NHTSA's CAFE authority, that is the Corporate Average Fuel Economy Authority governing automobiles and light trucks. It does not, of course, cover or even in any way turn on any other regulation that does affect tractor trailers. So there's no doubt.
So it's not talking about tractors and trailers. It's talking about a regular car and something we might hitch to the back of a regular car.
That's exactly the
okay. That's helpful.
Focus of the safe rule and the CAFE scheme as a whole, which does not cover tractor trailers.
Before I forget, do you have a sense of the question I asked Ms. Theodore about what this costs the industry?
Your Honor, I don't recall the specifics, but I can point you to the part of the record that does address that, and that is the impact analysis and the regulatory impact analysis. So the RIA, the regulatory impact analysis, begins at JA 429. The impact assessment by the agencies in the final rule, and this is not specifically the economic impact on the industry, but that section begins at JA 135. And within that section, my memory is that the agencies did address the economic impact on trailer manufacturers specifically. I apologize, I don't have the specific pages.
I'll stop interrupting you, at least for now.
Not at all, Your Honor. I do want to link the question you asked about the CAFE regulations to EPA's analysis of its statutory authority here, which I think confirms the point that Judge Millett was getting at in one of her questions, which is how the agencies here undertook a real-world analysis, a practical analysis of how tractor trailers as motor vehicles are perceived as a single vehicle proceeding down the highway by other vehicle operators. That's important here, and it does reflect as well the room that Congress left within both statutes. But when EPA was interpreting its authority under the Clean Air Act to regulate tractor trailers as motor vehicles, one thing they made very clear is that the tractor without the trailer or the trailer without the tractor is not itself a single vehicle. Only because the two are designed to work together are they a single motor vehicle. That's quite different, the agency explained, from an automobile or a light truck pulling a separate trailer, which is what I think you were referring to in the safe rule, if I recall correctly. Unfortunately, I don't have the safe rule in front of me. The agency explained that significant difference is what underlies its statutory interpretation here. The tractor trailer is the vehicle subject to regulation.
I guess I'm a little confused about that, because surely you regulate if you had someone who had one of these tractors and just liked driving this great big thing down the road, never attached trailers to it, that tractor would be completely regulated by, whether it attaches or not to trailers, that tractor is itself regulated by these provisions because it's transporting a person.
Your Honor, the question isn't whether any individual driver intends to use it. The question is whether the vehicle under 7521(2) is designed for transporting persons or property. And that tractor is designed for transporting property.
It's also designed for transporting the driver.
I don't think that's an accurate understanding, and that's certainly not the interpretation that EPA has given to that provision, and that interpretation is a reasonable one, Your Honor. The tractor is designed to function as part of the tractor-trailer vehicle.
I guess I'm having a little trouble understanding that, because, one, I've seen these tractors going down the road by themselves. Presumably they've dropped off a load, don't have another one to pick back, or they're driving to the next place to pick up a load. And it's definitely designed to transport the person to and from, shall we say, work, where they pick up trailers. It has, a lot of them have little cabs in the back with little bedrooms and everything. They're definitely designed to carry that person to and from hauling assignments, and then carries that person through the hauling assignment. And you have, are you saying you can't regulate the emissions of the tractor itself?
Judge Millett, the agency has not said that, and I'm not taking that position here. What we are seeing, what the agency has said, and what we are defending here, is the proposition that these tractor trailers operate as single vehicles on the highway. They're designed to operate that way as single vehicles. And each part of the tractor trailer is subject to the requirement that EPA imposes that any manufacturer of a motor vehicle, and that includes both the tractor manufacturer and the trailer manufacturer here, can be required to obtain a certificate of conformity under the Clean Air Act regulations. The any manufacturer language is what really does a lot of the work here, and I don't think that petitioner's argument fairly addresses the statutory scheme as a whole by focusing solely on the motor vehicle, because here the motor vehicle is the tractor trailer as a single vehicle. Both manufacturers are within the statutory requirement of any manufacturer that can be required by EPA to obtain the certificate of conformity. All of that is...
But it's not a vehicle even under your view. It's not a covered vehicle until the two are put together.
No, I don't think that's right, Judge Millett. It certainly is a motor vehicle when the two are put together. And by the way, I think you asked about, whether there are some operators, and again, it doesn't matter whether an individual operator does anything, it's how they're designed. But it's certainly true as well, and the record reflects that some operators do keep their tractor and their trailer combined full-time, essentially. Mm-hmm. But that's not essential here. And the key point is that the agency understood its authority to cover the tractor trailer when both parts are designed to work together, and that both manufacturers can be subject to those regulations.
Is there any manufacturer that manufactures both the tractor and the trailer? I'm
not aware of any, Your Honor. So, but again, the whole idea of any manufacturer is an expansive concept. The word any is expansive, as this court and Supreme Court have recognized. But fundamentally, it doesn't matter whether the Clean Air Act or USCA, as modified by ISAF, authorizes the agency, as long as it authorizes an agency to regulate tractor trailers, as long as the other statute does. And here, no matter what the court thinks about one authority, the other authority, in this case, NHTSA's authority under USCA, is ample to support the regulations of NHTSA to impose fuel efficiency requirements on tractors.
So, Mr. Byron, on that point, can you walk through the three things that I was asking Ms. Theodore about? How let's say that we find the EPA didn't have the authority to do this. Let's say we find that NHTSA did. NHTSA's regulation mentions EPA, I think, 400 times. And in particular, there are at least three things that the manufacturers argue just don't work in this regulatory scheme when you take EPA out of it. One's the compliance certificate, one is that only EPA issues, one is the standards that only EPA sets, and one is the testing that only EPA does. Can you talk about how each one of those things, what would happen to each of those things if we strike down the EPA's authority, but we find that NHTSA did have authority?
Certainly, Judge Walker, and if I may step back just for a moment to put that in context, the key point here is that all three of those are elements of the compliance mechanism that each agency adopted with respect to its own requirements. And so the fact that NHTSA required, in order to demonstrate compliance with the fuel efficiency regulation, required a manufacturer to obtain a certificate of conformity from EPA, that's merely a mechanism of demonstrating compliance with the fuel efficiency regulation. It's not itself a predicate that requires EPA to have independent regulatory authority under the Clean Air Act to set its own standards.
So are you saying NHTSA would allow a trailer to be manufactured even absent an EPA certificate of conformity?
Well, I think, Judge Walker, that two alternative approaches are equally available to the court in the scenario you've outlined. Where the court
I do want to hear them, but can you answer that one first? Would NHTSA allow a trailer to be manufactured that doesn't get an EPA certificate of conformity?
So yes, Your Honor, if this court were to hold that the EPA regulations providing a mechanism for trailer manufacturers to obtain a certificate of authority were themselves invalid, then yes, of course, NHTSA would permit other mechanisms to demonstrate compliance with the fuel efficiency regulations. This court
are those mechanisms in the regulations already, or would NHTSA make them up?
Well, Your Honor, I think there's not an alternative specified to obtaining a certificate of conformity, but there are other ways that NHTSA's regulation specifies that trailer manufacturers can demonstrate their compliance with the fuel efficiency regulations by submitting the compliance information either through EPA's database or directly to NHTSA, to its own database, the CAFE, or to the CAFE database. But
I thought you just said NHTSA won't allow a trailer to be manufactured if it doesn't get an EPA certificate of conformity.
Well, Your Honor, if this court strikes down, and this is the important point that I need to return to in just a moment, but if this court were to strike down the EPA regulation that permits trailer manufacturers to obtain a certificate of conformity, of course, as a consequence of that, NHTSA could not require trailer manufacturers to do something that this court said they cannot.
Okay, so that first of the three things is no longer a requirement. What about the other two? EPA sets the standards and EPA tests. What happens to them?
Judge Walker, can I just return to the other aspect of this that I didn't get to, which is that this court could strike down EPA's Clean Air Act greenhouse gas emission standards without striking down the provisions that allow trailer manufacturers, like other heavy-duty vehicle manufacturers, to obtain a certificate of conformity. In other words, the certificate of conformity is not available because NHTSA has specified that the certificate of conformity is required. This court could conclude that the certificate of conformity mechanism could remain in place to permit compliance with NHTSA's regulation. My point was that both paths are available.
Could you just say a little more on that? I'm sorry to interrupt also, as long as you're on that topic. So what would be, if we were to say that trailer is not a vehicle under the Clean Air Act, what would be EPA's authority to issue certificates of compliance?
Judge Garland, of course, a lot would depend on what this court concluded about the scope of the Clean Air Act and the EPA's authority. But unless this court were to conclude that its interpretation of the Clean Air Act precludes EPA from assisting NHTSA in its compliance with the fuel efficiency regulations. So
I'm asking what permits it to assist in that way. So assume all we hold is that it's not self-propelled. That means it's, the regulation of emissions of trailers isn't permitted. What authority remains for the certificate of compliance?
Well, Your Honor, remember the certificate of compliance mechanism in the EPA regulations is not directed solely to trailer manufacturers, but to all heavy-duty and in fact, other vehicle manufacturers as well. And here, NHTSA merely adopted the existing regulatory scheme. Now, it happens that the regulatory scheme at the time NHTSA adopted it, and again, this was to reduce the burden on manufacturers. So the petitioner here is turning a regulatory virtue into a vice. But the point of adopting that existing framework was to minimize the burden on manufacturers. In doing so, even if EPA didn't have authority to adopt that framework with respect to trailers on its own, the fact that it had adopted the framework didn't preclude, for other manufacturers, for example, wouldn't have precluded NHTSA from requiring trailer manufacturers to use that existing streamlined mechanism instead of adopting an entirely new burdensome requirement. Now, the fact is here, of course, there is a specific mechanism in the certificate of conformity requirement specific to trailers. And again, that's a virtue, not a vice. It actually minimizes the burden for trailer manufacturers by demonstrating that they don't have to do all of the same things that other vehicle manufacturers do. They just have to use the formula that's based on the model, the GEM model. But all of this is to say, just to go back to Judge Walker's question, that this court might, or it might not, conclude that the compliance mechanism in the EPA regulations is precluded by the Clean Air Act. If it does, then that wipes out the need to obtain a certificate of conformity to comply with NHTSA's fuel efficiency regulations. The other requirements of compliance would remain. If it doesn't, then that leaves to the agencies the available opportunities to specify the least burdensome, most consistent mechanisms for compliance with NHTSA's regulation. Judge Walker, if I may turn
very briefly, Mr. Byron, standards and testing, can you, as briefly as you can, explain how EPA standards and EPA testing can still continue if the EPA standards and EPA testing with regard to trailers can still continue even if EPA does not have the authority to regulate trailers?
Sure, Judge Walker, and standards are easy, and I'll just step back and remind the court that both Delta Construction and Massachusetts against EPA recognize that there is a scientific relationship between CO2 emissions and fuel consumption, so that the fact that the formula measuring fuel efficiency and CO2 emissions is the same is just a reflection of that scientific relationship. It's not a reliance on any EPA regulatory authority. And looking back as well in the context of the CAFE regulations that we were discussing earlier, EPA measures CAFE fuel economy compliance by measuring CO2 emissions from vehicles. That's how, in order to determine compliance with NHTSA's CAFE regulations. So historically, that's how CAFE fuel economy has always been measured for compliance purposes. So then with respect to testing, Your Honor, the question of testing, and this is just, again, the auditing function that applies to, I believe, all vehicles, at least all heavy-duty vehicles in this context. The fact that NHTSA has adopted a mechanism that reduces the burden by relying principally or initially on EPA's testing mechanisms that are in place, again, with respect to the broader industry, is a virtue, not a vice. And the fact, and the question whether there might be some other way for NHTSA, in the event it determines it needs to audit or test a particular vehicle or a particular technology, is not something that requires this court to strike down the standards themselves. There's no substantial doubt that NHTSA would have adopted the standards, irrespective of whether it could have relied on EPA's testing mechanism. I hope that answers the three questions you had, Judge Walker. I would just urge Judge Garland, if I may, turn to a question that you raised in petitioner's argument briefly. The question whether the function test in the severability inquiry is meaningfully different from the intent test. I think that a fair reading of the Maryland, DC, Delaware broadcasters case makes clear that it's not genuinely independent, and it's true, of course, that the court in that case italicized the word "and" when it linked the two inquiries, but then when it applied the function test, it did so in the context of assessing the agency's underlying intent, and emphasized, if I may, that that option A would not have been sufficient to achieve the commission's goals, and in fact would undercut the whole structure of the rule. Those references to goals and undercutting the structure seems to me turn as much on intent as on anything separate from intent. In other words, it seems that the court there merely disbelieved, if I may, the court's severability expression of intent when it itself analyzed the rules. In doing so here, the court can confirm readily that each agency has independent authority, exercised that independent authority, and validly expressed its intent that each set of standards can stand on its own independently.
I just ask a question. Do you then concede that when you're talking about two separate regulatory systems, the analysis is severability, as opposed to simply determining whether if one were to fall and one were to stand, whether the standing one's provisions that refer to the other arbitrary and capricious or something? I'm just not aware of severability being used in this context.
Judge Millett, the petitioners here framed this in terms of severability, so our brief did so as well in response. No party has briefed, as far as I can tell, whether the arbitrary and capricious standard would apply, and there's no argument that the NHTSA standards would be arbitrary and capricious on their own.
I'm talking about the regulatory provisions that cross-reference EPA.
I understand.
And you've made some arguments as to why it would still make sense, or I'm just trying to figure out whether do you agree we should be using the severability lens here, or simply looking at regulations cross references and figuring out what to do with that?
So I think that there are good reasons to look at this through the lens of severability, Judge Millett. And those reasons include the fact that the preamble was jointly prepared by both agencies together, that they intended to create a harmonized set of regulatory requirements for a single industry here for in order to reduce the burden. In that
EPA regulations come into effect 3 years earlier than the other ones?
And that's because each statute provides different lead time requirements, of course, and the agencies have independent authority that they exercise. Judge Millett, I don't want to preclude the possibility, as you suggest, that the court need not adopt a severability analysis.
Well, you need to tell me what the government's position is, right? If the government agrees with severability and is not arguing otherwise, then I don't know why we would spontaneously take on the issue ourselves.
Well, not only, I think, Your Honor, is it correct that you need not spontaneously take on the issues yourselves, but also because petitioner has not argued that the remaining NHTSA fuel efficiency regulations would be arbitrary and capricious merely by referring to EPA's regulations. I think they have waived that argument, and so it need not be addressed by the court in this context.
All right, thanks.
For those reasons, Your Honor, we'd urge the court to deny the petition for review. Thank you.
Thank you, Mr. Byron. Ms. Henderson. For the respondent.
Thank you, Your Honor, and may it please the court, Alice Henderson for the respondent interveners. I'd like to briefly address two of the issues related to EPA's authority that have been discussed, and then turn to the joint compliance regulations. I noted, Judge Millett, that you made a note of the authority that EPA would have to set a tractor standard that would be at a level that would require trailer improvements. And I wanted to note that the reason EPA structured the regulations the way it did here with obligations for both the tractor manufacturers and the trailer manufacturers is because of the way the industry has segmented itself. So the tractor manufacturer never comes into possession of a trailer. And that's why it's necessary to achieve emissions reductions from the whole vehicle to create obligations for both manufacturers. And TTMA doesn't deny that if a single manufacturer was in charge of building both the trailer and the tractor, that whole vehicle could then be subject to an EPA standard. But the Clean Air Act isn't written to allow manufacturers to decide which aspects of a vehicle could be subject to a motor vehicle regulation by splitting up the production among different entities. And I note that counsel for TTMA made the point that it wouldn't make sense under the Clean Air Act to require a trailer manufacturer to warrant that its vehicle would not cause the motor vehicle to be in noncompliance with an emission standard. This just proves that it doesn't make sense to treat a trailer as a part. It is fully 1/2 of this very large motor vehicle, the largest motor vehicle on our highways. And the fact that the Act isn't written in a way that would allow treatment of the trailer as a part just goes to show that it must be regulated the way that EPA has reasonably done so here, because otherwise you'd have to assume that Congress intended to create a really large gap in the regulatory structure, and it's implausible to think that Congress would want to regulate other heavy-duty vehicles that have cargo sections like UPS delivery trucks, but not the cargo section of a tractor trailer, which serves the same purpose, but at a much larger scale and with greater resulting emissions.
Is that argument, Ms. Henderson, a little bit different than the government's argument? I take the government to say, and I'm on page 12 of the red brief, Congress did not address the question whether the agency could regulate trailers. You seem to be saying that Congress wanted the agency to regulate trailers.
Our position is that EPA's determination that the tractor trailer is a motor vehicle is a permissible interpretation of ambiguity in the statute.
Well, see, now there you sound more like the government, that Congress really didn't make a choice on whether EPA and perhaps even NHTSA, actually it's NHTSA here too, should regulate trailers.
Sure.
Is that your position?
No, Your Honor. These are two separate rules that are operating under two distinct statutory authorities. Our position is that NHTSA has effectuated the unambiguous intent of ESA and should be upheld at step one of Chevron, and that EPA has permissibly interpreted ambiguity with regard to the meaning of motor vehicle in the Clean Air Act. I'd like to address the issue related to the compliance regulations. ESA creates authority for EPA to promulgate the regulations that it has here, and the authority that EPA has under ESA is completely separate from the authority that EPA has under the Clean Air Act to set an emission standard. And so all of the regulations that are necessary for a manufacturer to comply with a fuel economy standard can be upheld under EPA's ESA authority. So in the case, if the court finds that
you say with, I'm sorry, could you? It's hard to interrupt with lag. Could you cite the statutory provision in ESA that you're referring to?
Sure. So 32904 of ESA directs the EPA to calculate average fuel economy for a manufacturer subject to a standard under 32902B of the Act. And the state interveners lay out the statutory structure in their brief. And 32907 and 32910 of EPCA, the Energy Policy and Conservation Act as amended by ESA, also clearly contemplates a central role for EPA in facilitating implementation of fuel economy standards. And this is true of all of the vehicles that are covered under this rule,
just pause for a moment. I may not have all the necessary statutory provisions in front of me, but the 32904 says EPA shall calculate the average fuel economy of a manufacturer subject to. Now, which of the provisions that follow? What's the definition of manufacturer for purposes of that section?
So that 32904, which references manufacturers subject to a standard under 32902B, unambiguously includes manufacturers subject to a heavy-duty standard under 32902B1C. And that's what the state interveners argued in their brief.
Okay, thank you.
Sure. And so just going back to the functionality of the compliance regulations, if this court were to find that EPA lacks Clean Air Act authority, the remedy for that finding would not be to invalidate all of the regulations that could be upheld under EPA's ESA authority. And everything that a manufacturer would need to comply with a fuel economy standard is written in those regulations that EPA has clear authority to promulgate under ESA.
Ms. Henderson, could your argument with regard to the role of EPA under ESA cut against you? And here's why I'm wondering that. If ESA imagines a regulatory role for EPA, and if the EPA doesn't have authority under the Clean Air Act to regulate trailers, then it seems like maybe we should interpret ESA to not cover trailers.
I wouldn't say that's true, Your Honor. These are two separate and distinct statutes that serve completely different purposes, and this court in Delta Construction recognized that when it held that even if an EPA standard were vacated, the NHTSA standard would remain because it was a separate action with independent legal effect. And maybe just to clarify, EPA doesn't have authority to set an emission standard under ESA, but ESA contemplates a really central role for EPA in aiding in the implementation of a fuel economy standard, and that's because of the expertise that EPA has in testing. And that role for EPA has been understood under the Energy Policy and Conservation Act as well as ESA, which amended it.
And 32904C also says that to the extent practicable, fuel economy tests shall be carried out with emissions tests under the Clean Air Act. But there aren't, I'm trying to figure out how that intersects with the ability of NHTSA regulations to rely on EPA to do some of the measuring and certifying here. Does it help or hurt? Because they're no longer going to be doing, if they were no longer hypothetically doing emissions tests for trailers, would this support or not support that cross-reference to having them do the measurements and calculations for NHTSA?
I think it supports the position that EPA has clear authority to promulgate the regulations that it has to facilitate implementation of fuel economy standards. As you noted, it's to the extent possible to align those with emission standards, and if there aren't comparable trailer greenhouse gas emission standards in place, that wouldn't affect EPA's authority or ability to, execute its regulations that it has promulgated for this rule. And I guess I'll just note on that point as well that the compliance process regulations that we're talking about here are written as instructions to manufacturers about how to generate the input values for a formula. And then that formula spits out a number, and manufacturers are able to compare that number to that's a CO2 level, and compare that number to the actual substantive numerical EPA emission standards. So in no way are these regulations dependent on the existence of an emission standard. They're drafted to facilitate both the compliance with emission standards and fuel economy standards, but they aren't intertwined with the substantive emission standard.
It's interesting. I don't pretend to understand to be able to do the math that is in the formula, but I imagine that there's some part of the formula that is a variable based on the particular manufacturer. And there's some part of that variable that is a number chosen by EPA. Maybe the denominator is a number chosen by EPA. Maybe it's in there. I don't know where it is in the formula. But if EPA is choosing at least some of the numbers that go into that formula, not a formula that's all variables, but some of the numbers that go into that formula, I think that's different than just saying, well, there's a formula with nothing but X, Y, and Z's, and NHTSA can take that mathematical formula and decide what should be Y, what should be Z, and we'll make X the information we get from the manufacturer. Aren't those two different things, and which one are we talking about here?
That's a great question, and I think the best way to answer it is to say the regulations, as you correctly note, include values that a manufacturer has to generate by their own testing, as well as values that are coefficients that are plugged into the formula. And neither of those values requires EPA to do anything other than review the application that manufacturers submit. The coefficients, the values that EPA has created, as you mentioned, are static, and they're already written into the regulation. So there's nothing new being created when a manufacturer is seeking confirmation of its compliance with a standard.
But if I heard there in the middle, it is EPA that's picking the coefficients, not NHTSA.
So it's the coefficients are written into these compliance regulations and housed under Title 40. They support both EPA's emission standards and NHTSA's fuel economy standards.
So are you saying Congress picked the coefficients, or EPA picked the coefficients, or something else?
Well, this is a joint rulemaking between EPA and NHTSA, so I can't tell you all of the process that led to the development of those numbers, but I think it'd be fair to say that the agencies developed them together.
Okay, thanks.
I see I'm out of time. Thank you. And in closing, I'll just note that these are the largest freight trailers are the largest segment of the largest vehicle on our roads. They contribute substantially both to the air pollution and the fuel consumption that Congress designed these statutes to reduce, and I would urge the court to uphold both agency standards.
Right, thank you, Ms. Henderson. Ms. Theodore, we're out of time, but as we generally do, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. A couple quick points. So first of all, on this notion that there's some sort of gap here, the Clean Air Act has been around since 1965, and trailers haven't been regulated at all during that entire time. So it's completely plausible that Congress did not intend the regulation of trailers. On the EPA rules, I heard no response from respondent or interveners on what the word self-propelled could possibly be doing in the statute if it wasn't intended to exclude trailers, which also means that EPA can't get around that by claiming it's regulating tractor trailers. And the notion that a tractor without a trailer is not a vehicle, as I heard Mr. Byron say, doesn't make any sense. EPA has been regulating tractors by themselves for years, including in the Phase 1 standards. So let me turn to the argument that the ESA gives EPA authority to do this is just completely wrong. So Section 32904 only authorizes regulation of manufacturers. Manufacturers is defined in Section 3290114 to mean a person engaged in manufacturing automobiles, and Section 3290113 defines an automobile as something that's less than 10,000 gross vehicle weight, meaning not a heavy-duty vehicle. And that's because 32904 actually isn't part of the ESA. It was added in 1994 when NHTSA only had authority to regulate light-duty vehicles. And if you look at the government's stay opposition, they admit that this provision, 32904, does not authorize the regulation of trailers, even under their theory that a trailer is a vehicle.
Well, 32904 just says a manufacturer subject to Section 32902B, A-N. And so it seems to me that just the question is if trailers are included in the ESA definition of motor vehicle, then they are a manufacturer subject to 32902B and therefore covered by 32904. Am I wrong?
I don't think so, Your Honor, because they're not a manufacturer. Manufacturer is defined in the statute, and it's defined to mean someone who manufactures automobiles, which is defined to exclude heavy-duty vehicles.
Well, then why would they refer to 32902B through D, which includes then both automobiles and heavy truck vehicles and things like that?
It's because 32904 was enacted in 1994 before that other provision was amended, and it's just a cross-reference to B when B was different before the ESA was enacted. But in any event, I mean, the EPA doesn't rely on ESA, so it doesn't really matter, because what matters is what the EPA actually claims regulatory authority under. And at JA 238, they make clear that they're only relying on the Clean Air Act. So turning to the severability analysis very quickly, the question is not whether every provision of NHTSA's rules couldn't function. It's whether striking EPAs would impair the function of NHTSA's rules. It's very clear that it would, and I heard no explanation of how a manufacturer could possibly determine whether they comply if they can't get someone to tell them that their trailers comply. But also, I mean, the testing regulations, trailer manufacturers, they can't simply plug numbers into the equation. They have to do tests, and the regulations make very clear that EPA has to pre-approve those tests. And so in the absence of EPA acting to pre-approve those tests, you can't even figure out whether you comply with the regulations in the first place, even putting aside the absence of the certificate of conformity. In response to the question whether severability is the right analysis, I certainly think the United States has waived any argument that it's not. And again, the Delta case from this court, it applied a severability analysis to a joint EPA and NHTSA rule.
We're talking about them being bifurcated. I don't know if that's... Well, all it did was talk about them being bifurcated.
So the Delta case is a case that said that the petitioners didn't have standing because they only challenged the EPA portion of the rule, and there's no regressibility because the NHTSA portion of the rule would stand in the absence of the EPA portion of the rule. And the court said the question in deciding whether that was so was whether NHTSA's provisions were dependent on EPA's. So that's the same question that we're addressing here.
Dependent is not the same thing as severable. Like they could very well be whether they can operate in a non-arbitrary way without cross-references, given the cross-references. That's all I'm struggling with. I guess I didn't see, they talked about whether the fuel economy standards cannot be bifurcated from the greenhouse gas emission standards, but it wasn't clear to me that that was a severability analysis as opposed to.
Well, you know, however you want, whatever you want to call it, I think it's the same functional analysis. The question is whether the NHTSA rules can operate as law without the operation of the EPAs. And you could call it a severability analysis, you could call it an arbitrary and capricious analysis, which we certainly haven't waived since we argued that the NHTSA rules were non-functional and made no sense without the EPAs. So I think the court can call it whatever it wants to call it, but the question is really the same. You're looking at the rule and you're looking at whether sort of what the scope of the remedy is and what you have to vacate, and you can't leave NHTSA's provisions if they make zero sense without the EPAs, which they do make zero sense. And again, that's the world we're living in right now.
All right. Are there further questions from the bench?
32904C, is that limited to cars, or would that also apply to covered heavy vehicles?
I'm sorry. Let me just pull up 32904C. I'm sorry.
It talks about each model, so I'm not sure if that means cars or not.
Yeah, so 32904C also refers to a quote-unquote manufacturer. Mm-hmm. Manufacturer is defined in statute with reference exclusively to non-heavy duty vehicles.
Okay, thank you.
All right, we'll take the matter. You have something more?
I would just close by asking the court to act swiftly on the stay, because it really is creating an enormous problem for trailer manufacturers right now that they can't take orders while assuring their customers that they can actually sell those trailers in 2020.
Can I ask one very quick question on the stay thing? It seems like has the harm already been done, the irreparable harm? I mean, you all have to start preparing for January 1st as if this rule's going to be in effect, and I suspect you can't start doing that tomorrow, September 16th.
Absolutely, Your Honor. Yes. I mean, there is irreparable harm going on right now every day, and that's why we would ask the court to act as swiftly as it can on this.
But there's some irreparable harm that has not yet happened.
Well, for example, if a trailer manufacturer could take an order tomorrow, that would be very helpful. And if the court took regulations, then a trailer manufacturer could do that and could offer a trailer for sale in 2021.
When did the irreparable harm start?
I'm sorry?
When did the irreparable harm start?
It's been ongoing. It depends on each trailer manufacturer because, you know, they sort of have...
Give me a rough estimate.
I'd say in the last month or so. I mean, trailer manufacturers are starting to take orders right now. There's like a 3 or 4 month lead time.
Okay, thanks.
So given the stay on EPA, what have the trailer manufacturers been doing with respect to compliance?
So the trailer manufacturers have asked EPA if EPA is going to issue certificates of conformity. EPA said no. The trailer manufacturers have asked EPA if there's anyone in NHTSA they can talk to. EPA said it has no idea. So the trailer manufacturers are sort of just planning for trying to think about, you know, building warehouses to store this equipment and, you know, potentially to comply even in the absence of a certificate of conformity. But basically it's impossible. I mean, that's.
Have you talked to NHTSA about? You said they've talked to EPA. Have they talked to NHTSA about what to do?
There's no one at NHTSA. There's no one at NHTSA who will talk to them about what to do. The trailer manufacturers have asked, and this is in the declarations, they've asked the EPA, like, who at NHTSA will implement this, and EPA says they have no idea.
Okay. Barring further questions, then we'll take the matter under submission. Thank you, and the court will take a brief recess.
Thank you.
Honorable Court will now take a brief recess. I am going to ask IT to please stop streaming. I am stopping the recording. And attorneys, law clerks, J's, and IT, I am putting you all in the waiting room. You will not be able to hear or see anything while you're in the waiting room, which is perfectly normal. I will bring you back when the judges are ready to hear the district case. Thank you.
You have been put on hold by the host. You cannot listen or talk until the host releases the hold.
IT screening again. I am going to start recording. Meeting again. It is recording. And all right, this honorable court is now again in session. Case number 19-5359. United States Department of Homeland Security et al. Mr. Sheldon for the appellant, Mr. Ramkumar for the appellate.
May it please the court, my name is Robert Sheldon. I'm arguing on behalf of the appellant, Alder Cruz. I'd like to reserve 3 minutes for rebuttal. Virtually every person in the United States has ancestors who came here as immigrants. Many of them are fleeing persecution. Even those who came in the Mayflower were fleeing religious persecution. None of these ancestors were forced by armed police to go to a place controlled by criminal gangs where they or their families were likely to be murdered, raped, kidnapped, or robbed, especially with no hearings or procedure. On June 24, 2018, President Trump tweeted, "When somebody comes in, we must immediately, with no judges or court cases, bring them back from where they came." Then in announcing the migrant protection protocols, the defendants denounced misguided court decisions and outdated laws. We can see the administration first made the decision to force 65,000 asylum seekers, including 16,000 children, to Mexico, and then they looked around for a law to justify their actions. These asylum seekers included Mr. Cruz, a college senior who escaped Guatemala when his life was threatened by gangs who had already murdered his best friend because of his sister's church activities. So the defendants found the statute, 8 U.S.C. 1225 B2C, and decided to claim this for their legal authorization. However, the statute doesn't work at all for their purposes. I'd like to explain first why the MPP isn't authorized by the law at all. Second, why it especially isn't legal for people like Mr. Cruz, who were in the United States when they were apprehended. And I'd like to move on to due process, withholding of removal, international law, injunction factors, and other arguments.
Before you start, can I just ask for what the status of his removal proceeding is?
He has barely begun. I mean, he went to master hearings, and he hasn't even been able to submit his asylum application. He was supposed to submit it in court, but the court was canceled. Okay. Because, you know, whatever, all the MPP courts are canceled right now. So his was among them. So he's never even submitted his asylum application. Thank you. So Section 1225 has two relevant subsections. B1, which is people with no documentations, and fake documents, which is obviously which all the MPP people, including Mr. Cruz, should be under. And B2, which is for other people, basically those who arrive to the United States legally with documentation, but they're inadmissible. In other words, they've committed some crime or they have some other inadmissibility. The Supreme Court in Jennings versus Rodriguez said these are two separate categories. And the Ninth Circuit and Innovation Law Labs found that these subsections are mutually exclusive, which we completely agree with. Obviously, a B2 can't be a B1 because they have documents. But at the same time, there's no way a B2 can be a B1 for several reasons. First of all, the title is Other Aliens, which, you know, as the Ninth Circuit said, other means other. And then second, the statute is, you know, this is the main reason. I mean, the statute specifically and expressly has a section called exceptions, and it specifically says you cannot apply B2 to someone to whom B1 applies.
Mr. Sheldon, let me interrupt you if you could. If someone who is eligible for B1 doesn't fit ever into the B2 box, how is it possible for immigration to do what they frequently do, which is take someone eligible for the B1 box and instead send them into the non-expedited proceedings provided for in the B2 box?
Okay, so that's a great question. You know, the statute clearly says they can't do that, but then the BIA in a case called ERM said they can go ahead and place them in proceedings. I mean, the BIA basically said that when Congress said, shall be removed if they don't go into credible fear, they actually meant will. I mean, those are the words.
So I take it sounds like your argument is that that although it is frequently done, the statute actually prohibits it. And if we adopt your reading of the statute, then we would be concluding that this common practice by Homeland Security is illegal.
No, Your Honor, no, not at all. Because EMR doesn't say that. I mean, that's what the government says EMR says, but they're completely, that's just simply not true at all. EMR says they can be placed in removal proceedings. Nowhere does it say they can be placed into B2, which is just a complete invention on the part of the government. I mean,
let me try asking a different way. Is it legal for Homeland Security to take someone who qualifies for B1 expedited removal and to put them into non-expedited removal procedures?
Absolutely not. I mean, there's no provision whatsoever. The law clearly says they can't do it, and ERM doesn't say that either. I mean, they like I said, they needed to find a statute, and they just forced it in, but it doesn't work at all.
Is there a tension between your two statutory arguments? Let me tell you why I think there might be, and then you can tell me why. If I'm off base, you can tell me why I'm off base. On the one hand, you make the argument that you've just been making, that an immigrant is either in the B1 box or the B2 box. The B2 box, with regard to undocumented immigrants, applies to people who have been in the country for 2 years or more. That's because the B1 box applies to people who are arriving without documents and to people who have been here for less than 2 years without documents. If that theory is right, that the B2 box only applies to undocumented, among the undocumented population, the B2 box only applies to those who have been here for 2 years or more, how can your second argument be correct? That B2-3, when it says an immigrant who is arriving in the present tense, how could that ever apply to anyone? Because as you've defined it, in the universe of undocumented immigrants at least, B2-3 is not supposed to apply to anybody who's been here less than, B2-3 is not supposed to apply to anyone who has been in the country less than 2 years. At the same time, you can't be arriving if you've been here longer than 2 years.
Right, thank you, Your Honor. That's a completely misreading of the statute. The statute divides into two groups. Okay, B1 is people without documents and people who have fake documents. B2 is everybody else. So this is just I guess the government likes to create, what they're trying to do is create a lot of smoke and make this a lot more complicated, which, immigration law is complicated, but the statute is really pretty simple in that sense. It's, B2 is...
Mr. Sheldon, let me ask, can you give me an example of an undocumented immigrant that B2-3 would apply to?
Your Honor, that's okay. Basically, everybody who has documentation. In other words, anyone, let's say they're coming...
No. Mr. Sheldon, can you give me an example of an undocumented immigrant that B2-3 would apply to?
Yeah, someone who came in a tourist visa and overstayed. They are legally entitled to be in the country, and then they overstayed. Actually, B2 is supposed to be more for people who are coming to the United States, so it really wouldn't apply that much to people in the United States if that's what the court's referring to. But, it could. It could under the terms, but it's really designed for people that are arriving to the United States that have documents, that have a legal status, have a visa, have a legal status, but they're inadmissible. That's what B2 is for, which obviously excludes everybody in the MPP. It's really very, very straightforward.
Can I ask a fact question? I take it Mr. Cruz was 300 yards from the border. Do you know how long he'd been across the U.S. border, time-wise?
I'm sorry, Your Honor. We don't know the exact time. He says, long enough to go 1,182 feet. It wasn't a terribly long time, but certainly...
and my last question for now, and then I'll get out of your way and out of my colleague's way. Throssingham says that an immigrant who is 25 yards, well, it dealt with an immigrant who was 25 yards to the border, and it said that immigrant has not entered the country. That immigrant is arriving. I suspect you will tell me that anyone who's 26 yards or farther from the border has entered and is no longer currently arriving. Is that right?
Yes, Your Honor, that's completely correct, and for a lot of reasons. I mean, the due process clause, I think the court would that Judge Walker, you would agree that it's an extremely important goal of the framers of the Declaration of the Constitution. They wanted to protect individuals from the executive branch more than any other purpose of the Constitution. And and then we've got the fact that when they wrote the Constitution, I mean, everybody, there were immigrants everywhere. So then they deliberately, when they wrote the due process clause, they used the word persons instead of the word citizens because they wanted to include immigrants. I mean, that's obvious. For example, 3 of the first members of the U.S. Supreme Court were immigrants. I mean, the idea that they wouldn't have applied it to immigrants is actually quite absurd. So, I mean, that's why, that's the reason. So there's been, and not only that, there's been a long history throughout, the entire, since the Constitution was written, that they said, a bright line rule. If you're in the United States, you have a right to due process. If you're outside the United States, you don't. And that's been as clear, I've got a ton of quotes I can, where they said anyone in the United States, legal, not legal, these are major cases that have been cited over and over. Matthews v. Diaz, I mean, on and on, Zadvitas, and just a whole series of cases where they way back to 1886, where they said anyone within the jurisdiction of the United States is entitled to due process. And, this case, Thrassighian comes along, and it's kind of an aberration. I mean, it's kind of the first time the Supreme Court has decided not to give due process to someone physically in the United States. Although, the government comes up with all these arguments, but they're just not true. I mean, what the question is sometimes in the Rafferty case from the circuit and Landon v. Placentia, it's whether to extend it to people outside who are entering. But the law is very clear. If you're in the United States, you have a right to due process. If you're at the border, the entry doctrine is another story, but that doesn't apply in this case. So for us, again, it's very troubling because, I mean, there literally is no principled way to limit it. I mean, if immigrants have due process, if everyone has due process, because it says persons, then why not citizens? And can you apply it to U.S. citizens on the border? I mean, why not? So we just think it's a very troubling decision. We would ask the court to limit it to the 25 yards, which they actually did. I mean, in their own decision, they said it should only be applied to people who are in the respondent's position, which is 25 yards from the border, and also people who were caught, which the appellant here wasn't caught. He turned himself in, so we think that's a distinction. I would just ask the court to limit the rest again to the facts, which is what the court actually did. Thank you.
Can I ask you about and I don't speak French, so I'll say your non-refoulement interview. Sorry, I'm butchering that for the French people. If he were, what do you think that would entitle him to beyond the hearing that he already got? Is it just review by an immigration judge, or do you think then judicial review of the immigration judge's decision? What are you saying that since he eventually got the interview, is your complaint only about the process for that interview, or are you claiming review process? I'm just unclear.
Thank you, Your Honor. That's, basically, to quote Judge Fletcher in the Ninth Circuit, I mean, you're giving them nothing. I mean, they don't even ask them the question. They don't say, are you afraid to go to Mexico?
Oh, but in his interview, they did ask him that.
But not before they threw him out of the country. I mean, this was after he was brought back a month later. But before he was thrown out of the country, he wasn't asked anything. And they're expecting somebody to go to, the Border Patrol and say, I'm afraid to go to Mexico, which, you have to look at these people. I mean, they've been abused. Some of them have been abused by their own government, by their own police.
He got a later interview. If he had gotten the same interview he got later, right before they returned him to Mexico for the first time, would that have sufficed?
For a lot of reasons, no. I mean, that, you know, the standard that they're giving is more likely than not, which is the highest standard, you know, that they could possibly get. I mean, in credible fear, they ask, you know, do you have a credible fear even, which is a very low standard. It's like 1/10 of the standard. This is extremely high standard that they're giving right at the initial stage. I mean, you know, it's basically, you know, ever since the 1200s, I mean, there's certain basic requirements to due process, and one of them is to have an.
I don't want to. I just want to talk about. Sorry, I don't want to lose track of what I'm asking.
Oh, I'm sorry. The international
the obligations for non-refoulement. So your first point is that it should have happened right away the first time before he went, and the standard of review is wrong. They should ask him. He shouldn't have to spontaneously raise the concerns. Is there anything beyond that?
Notice before the hearing. I mean, there's a lot of things he should have been given. Right to counsel. I mean, you know, lawyers are pretty important to these procedures, more than even, you know, if it was Americans. I mean, these are people. Some of them are children. I mean, they're 10-year-old children. Some of them are, you know, they've been raped in their countries. They've suffered horrific persecution. I mean, to expect them just to know what to do in a foreign country. They don't even give them a translator, by the way. I mean, that's not even required. It's really, I mean, you know, Judge Fletcher said you're giving them nothing. I mean, literally, there's nothing there. You know, a right to, if they ask, they get a hearing, and then the highest possible standard is applied to them. So, you know, there's no way this meets either due process or the United States obligations under the withholding of removal statute, which, you know, is very clear. You cannot refool somebody. You know, if they will be subject to persecution, then the government tries to get around it by saying, well, it's Mexico. It's, you know, but nowhere does it say you can't be sent back to your, you know, it doesn't say it has to be your homeland. It says to any country, and that would include Mexico. So clearly, the government has an obligation to ask questions and to give them some kind of a fair hearing. You know, something that's not just, you know, someone basically supposedly asking them questions without any, you know, with no process whatsoever, and then it's supposedly reviewed. And apparently, you know, just anecdotally, I mean, the reviews are basically, you know, if it gets granted, then the reviewer just turns it around and says, no, you shouldn't have granted this case.
All right, thank you, Mr. Shell. Let me ask, is there anybody else on the panel who has a question? Because we're out of time.
Okay, Your Honor, I haven't even gotten to my main argument, which is the arriving alien. You know, that he was in the United States, which I really would like an opportunity to.
Go ahead. I thought you had discussed that argument with Judge Walker.
No, Your Honor. I mean, that's you know. So our first argument is the statute doesn't apply to anybody. The MPP should not be applied at all. But then our even strong, you know, and that we think is 100%. But then our even stronger argument is that it certainly shouldn't be applied to people who are in the United States. Because the statute right on its face is titled "People who are arriving on land." You know, the title says "arriving," and then the subsection says "arriving on land," and you know, arriving is a very plain meaning. I mean, everybody knows what arriving means. As the court, you know, in this case, Millett Vasquez said, the only other court that's looked at this, I mean, they said, look, you're either arriving or you arrived. There's only two possibilities, and you know, the client arrived. The appellant arrived. He's not arriving. And you know,
the Supreme Court definitely said in Thurigasian that it's not just the moment of crossing the border.
Right, so that's due process, Your Honor. We're just talking about the statute here. I mean, the statute, they have no right to use the statute against someone in the United States. The statute says arriving on land. I mean, my client was not arriving. The statute doesn't apply. Even if they had the due process right to do this, the statute just can't be more clear. I mean, arriving on land is not, you know, it's a very plain meaning. We don't need to use any textual analysis. And then you know, the word arriving on land is not used a lot, but the word arriving is used as arriving alien, and that's a very, very common phrase in immigration. And arriving alien means somebody who's arriving at a port of entry. The definition is very clear. It's under 8 CFR 1001.1Q. It's someone who's coming or attempting to come to a port of entry. So you know, I mean, they just really cannot use this.
But yeah, we have the parenthetical in this particular provision, whether or not it's a port of entry.
Right. So then they're using this convoluted explanation. So of course they're basically saying Congress doesn't know how to say inside the United States. And when they said inside the United States, they actually said whether or not a designated port of entry, which of course, I mean, why wouldn't Congress just say it if they were planning to overturn years and years of law? But then, and then they're claiming they have a right to apply at 96 hours after entry, which, I mean, they're saying someone 96 hours in the United States is arriving according to their definition, whether or not. But anyways, we would just really like to give an explanation for that. I mean, there is a very simple explanation, which is it says whether or not a port of entry is defined as a place with a port director. Okay, and it just turns out that there's a lot of places on the Canadian border which are called border crossings, but they're not called ports of entry. And, and I mean, I can give one, it's called Port Covington on the New York-Quebec border, but there's many, and they're just little border crossings with maybe 100 people cross a day. And that's what Congress meant. I mean, that's what.
So, Mr. Sheldon, let's take that example. Let's say that there's a border crossing between Canada and the United States, but it's not a port of entry.
Correct.
2BC applies there. Give me an example of someone who would fall under 2BC at one of these Canadian-U.S. border crossings. How far into the United States are they in order to trigger 2BC?
No, border crossings are exactly the same as ports of entry, except they're smaller. I mean, that's the only difference. So they're, they're little crossings. So they would stop them as they're crossing the border before they cross the border.
So you're saying they were stopping with 1 foot in Canada and 1 foot in the United States?
No, Your Honor, they stopped them at the border crossing. It's exactly the same as a port of entry. They stopped them, and Congress just. Okay, let me just quick. I mean, when we get to this whole section, the contiguous removal, who were they referring to? What did Congress, it's really a question. Why did they put in this whole statute? And we don't think it had anything to do with Central Americans. And the question is, who's arriving at the U.S. border that has a right to enter, but is inadmissible? And, it's not Europeans, because they would fly here. They wouldn't come to a port of entry, the border. It's not Asians, it's not Latin Americans, not even Central Americans. They would fly here if they have a visa. They don't drive up. So really, we think it applies to Canadians. And that was the whole purpose of this statute, is really, I mean, it's 35 million people on the U.S. border that are legally entitled to enter, and many of them are inadmissible, and it actually makes sense. I mean, who wouldn't rather be in Canada, in Toronto or Vancouver while you're waiting for the proceedings? And I just wanted, this comes directly from the case Matter of Sanchez Avila, which is the case which was the inspiration for this whole statute, the statutory section. And it says, in that case, it says on page 454, the certain states along the northern border of the United States, aliens are routinely returned to Canada to wait their exclusion hearings. In Buffalo, New York, for example, approximately 120 to 140 aliens are placed into exclusion proceedings each week and returned to Canada to wait their hearings. Parole of an alien into the United States from Canada to wait exclusion hearings are rare exceptions. In other words, this was really required for Canada, and it actually makes a lot of sense. That's what this statute was put in there for. If you read Matter of Sanchez Avila, it was really put in for a very specific purpose. It never crossed Congress's mind that this is the way it's being used. And that's, there's so much proof of that. Because to mention Mexicans, like they don't even say maybe a Mexican would want asylum, which, they spent so much time writing all these provisions of B1. I mean, Senator Leahy and others were fighting, to make sure it included all these rights for asylum seekers. And then the government wants us to believe just that they simply threw in this provision, oh yeah, you can put them into Mexico with no protections whatsoever. That's not what it's for, Your Honor. So it really, it doesn't apply. I mean, what they said in the Ninth Circuit, they just said that, there's no plausible way the statute can be read to apply to apply to the MPP, and then they said the government's making baseless arguments in support of an illegal policy, and that's pretty much what it is. And then but they're not even considering the fact that because they're the Ninth Circuit, the people weren't even in the United States. So my point was in the United States, the opponent was in the United States, which makes the case so much stronger because of the language, arriving on land, and then the due process arguments.
All right, Mr. Sheldon, we'll let you reserve a little time for rebuttal. We're out of time. We hear from the United States.
May it please the court, Archit Kumar for the government. The district court did not abuse its discretion in denying the preliminary injunction motion. With the court's permission, the government will address the statutory claims first, the non-refoulement claims second, the constitutional claims third, and will then briefly conclude by addressing irreparable harm.
Can I just ask you to reverse that order for just one moment? Sorry. This question of irreparable harm. I'm not saying we are, but again, hypothetically, if we were to decide Mr. Sheldon is right as a matter of statutory construction on one or both of his arguments, then is irreparable harm relevant? That is, not if we decide likely victor on the merits, but if we decide he is the victor on the merits.
The government's response would be that that consideration would still be relevant, Your Honor, and the reason for that is that this court has always described irreparable imminent harm as a critical part of the four-factor calculus used to assess preliminary injunction motions. And importantly, the showing of irreparable harm... Are you familiar with our opinion in the United States Association of Reptile Keepers versus Zinke, 2017 opinion? Briefly, Your Honor. Okay, well, in that case, we held that we can, in reviewing preliminary injunction issue, we can decide fully the merits because it's the first question. And if we decide the merits fully and decide that he is correct that this is a statutory violation, that's the end of the matter. And it makes sense that that would be the end of the matter because whether there is harm to the government or not, or harm to the plaintiff or not, once we decide the merits, there's nothing left to be decided. Yes, so, Your Honor, in that situation, the government would submit that it would essentially be a conversion to some sort of dispositive motion. But again, that is simply not the posture of this case. And in any event, the government strongly disagrees that Mr. Cruz has shown a likelihood of success in the merits. And I understand your argument on the second point, but on the first point, let me just read from our own opinion. We note that the procedural context of this appeal, which was from a preliminary injunction, does not prevent us from definitively deciding the merits of the clause's meaning. I mean, I think we've decided this question. I don't mean to belabor it, but if we were to decide that you're wrong, and not just that he's likely to succeed on the merits of the statutory argument, but that he does succeed, that would be the end of the matter. Just like in any case, once we conclude that the government violates a statute, we vacate the regulation under the APA. But now you can go back to your first argument.
Wait, before you do that, let me ask one more procedural question. If the Supreme Court grants cert on Innovative Labs before we've issued a decision, I'm sure that Mr. Cruz would say we should continue full speed ahead and decide our case. What do you say we should do?
The government shares that view as well, Your Honor, and the reason for that is this appeal raises a number of distinct issues not raised in the petition currently pending before the Supreme Court. Okay. So turning first to the two statutory claims. Do you know the status? When was cert filed in that case? Do we know conference listing? Do you know anything about that? We do, Your Honor. My understanding is the Supreme Court is slated to consider the petition at its September 29th conference. And of course, the government will promptly inform this court in the event that cert is granted. Okay, thank you. So turning first to the two statutory claims, Cruz makes two arguments on appeal. First, that he is not an alien described in subparagraph A because he could have been placed in expedited removal proceedings even though he was not. Second, Cruz argues that he was not arriving on land when he was apprehended shortly after illegally crossing the border, and the government will address each of those arguments in turn. First, Cruz is an alien described in subparagraph A, because aliens described in subparagraph A are applicants for admission who are not clearly and beyond a doubt entitled to be admitted, who are placed in full removal proceedings under Section 1229A. Cruz is an applicant for admission who was not clearly and beyond a doubt entitled to be admitted, who was placed in full removal proceedings under Section 1229.
Hang on. The statute says subject to subparagraphs B and C. So that language is all subject to subparagraph B, which then says subparagraph A shall not apply to an alien who is a crewman, someone to whom paragraph 1 applies, or who is a stowaway. So we have to, if you're within those exceptions, then you don't go to subsection 2 here, right? C, for instance, correct?
Yes, Your Honor. So Cruz's argument rises and falls entirely with Section 1225B2B2. That is, he claims that subparagraph A does not apply to him because he is an alien to whom Section.
Well, let me back up and just to have some context here. If he were a stowaway, one of the neighboring provisions, could the government still put him into Section 12298 proceedings as a matter of its own prosecutorial discretion or statutory interpretation?
So the BIA discussed this, Your Honor, in matter of ERM and LRM. The INA prohibits DHS from placing stowaways in full removal proceedings. Right. It makes clear that they lack. Right. So that third exception is someone who categorically cannot be put into these proceedings. What if he were a crewman? So if you were a crewman, Your Honor, my understanding is he would be similarly situated to an alien like Mr. Cruz, who could have been placed in expedited removal proceedings but was not. And in this case, Section 1225B1.
So B3 there is a categorical prohibition, but B1 and B2 are not, is your position?
Yes, Your Honor. And as the government demonstrated in its brief, the reason Section 1225B1 does not apply to Cruz is because the categories of aliens amenable to being placed in expedited and full removal proceedings overlap. That is to say, aliens who lack proper documentation, Mr. Cruz, who could theoretically be placed in expedited removal proceedings, are also applicants for admission who are not clearly and beyond a doubt entitled to be admitted.
Congress didn't seem to think they overlapped. It says, it entitles subsection B, inspection of other aliens, and that other aliens heading was Congress's duly enacted choice of phrasing. So it seemed to think there wasn't this overlap.
So, Your Honor, the government's view is the view articulated in the Ninth Circuit's motions panel decision in Innovation 1, which is the other aliens and the differentiation between the categories only occurs after the inspection decision is made. And again, that stems not just from the overlap I mentioned, but also from the plain text of Section 1225B1A1. Section 1225B1A1 notes that an alien inadmissible on specified grounds shall be ordered removed without further hearing or review unless that alien is referred for and passes a credible fear interview. Section 1225B2A, by contrast, provides for a different process whereby the alien is entitled to a full removal proceeding before an immigration judge. And indeed, Jennings described the two provisions in the same manner. Here,
well, Jennings very much described these as two distinct categories of aliens. Described them out as marked them out quite distinctly. So I'm not sure what to do. Is Mr. Cruz someone to whom the expedited removal provision applies, but the government chose not to put him through those proceedings and chose to give him different proceedings?
Your Honor, the government's view is that Mr. Cruz is not an alien to whom Section 1225B1 applies, and I want to circle back to Jennings briefly and the fact that he described the two categories as separate, because, again, the government's view is this comes back to what the Ninth Circuit articulated in its motions panel decision, which is these are post-inspection mutually exclusive categories, not pre-inspection mutually exclusive categories. And the reason for that stems, again, from the overlap between the aliens amenable to being placed in both proceedings, as well as the fact that just by the plain text of Section 1225B1A1, by its terms, it does not apply to Mr. Cruz. He was not ordered removed without further hearing or review, nor was he referred for a credible fear interview. Instead, he was entitled to a full removal proceeding before.
Oh wait, but the ordered without further hearing is not a description of people who are covered by the expedited removal provision. It's a command to the officer as to what they should do with someone who is arriving, right? It's not part of the definition of who is subject to expedited removal. It says what will happen to them.
Yes, Your Honor, but the government's view is that provision uses the word shall and commands that immigration officers shall order the alien based on specified inadmissibility grounds, order the alien removed without further hearing or review, and that simply did not occur here. So, in other words, there are two.
So you couldn't apply expedited removal to him. You could never have applied expedited removal to him. Could you have?
So the government's view is that DHS does possess prosecutorial discretion to apply expedited removal to similarly situated aliens, but elected not to exercise that discretion in this particular case.
So he is someone to whom, I guess in your view, both the expedited removal and the 1229A proceedings apply. And so you chose.
The only reason I want to disagree with that characterization is the government would not concede that he is an alien to whom Section 1225B1 applies in any way because he is an applicant for admission.
What do you mean by prosecutorial discretion? I mean, if it doesn't apply to him, there's no prosecutorial discretion at all.
The reason I mentioned that is there are no fixed immutable categories of B1 and B2 applicants, and this is the fundamental error that the Ninth Circuit made in the merits decision that it issued, which is that it assumed that there was this taxonomy whereby aliens arrive at the border with a fixed category and that aliens who lack proper documentation are categorically B1 applicants. But that is simply not the case.
But the other things in B, crewmen and stowaways, are pretty much categorical status, right? That's a categorical status. It's whether you're either a crewman or a stowaway or you're not. Correct?
Yes, Your Honor. But again, I would point
why
to
wouldn't capital B Romanet 2 have the same operation as capital B Romanet 1 and capital B Romanet 3?
So again, Your Honor, the government would just go back to the overlap between the two provisions, the categories of aliens amenable to being placed in both provisions, and would also point this court to matter of ERM and LRM, which described the purpose of Section 1225B2B2, which was just to make clear that aliens who are actually placed in expedited removal proceedings lack an entitlement to a full removal proceeding because that would produce an incongruent result. And here, there's no basis.
I'm sorry, I think I didn't hear. Could you say that again? I'm not sure I heard properly. I apologize.
Yes, Your Honor. So in matter of ERM and LRM, the BIA examined the purpose of Section 1225B2B2, which is central to this appeal. And in that case concluded that it did not strip DHS of prosecutorial discretion to place aliens like Mr. Cruz in full removal proceedings, but rather simply served a clarifying function that aliens who are actually placed in expedited removal proceedings are not entitled to full removal proceedings. And so the government's view is based on that limited clarifying function. There is no basis to conclude that in the same provision, Congress intended to exempt a large swath of aliens from contiguous territory return. Turning to the next statutory argument, in the government's view, Mr. Cruz's claim that he was not arriving on land when he was apprehended shortly after crossing the border illegally is foreclosed by the BIA's recent decision in matter of NDCV, which the government notified the court of via its Rule 28J letter, as the factual circumstances there are substantially similar to the circumstances here. The BIA's decision in matter of NDCV is reasonable, is consistent with the plain text of Section 1225B2C, and is entitled to Chevron deference. In matter of NDCV, the BIA drew heavily on the fact that both Section 1225A1, which defines applicants for admission, and Section 1225B2C both use the phrase whether or not at a designated port of arrival, and accordingly concluded that an alien apprehended near the border shortly after unlawful entry was arriving on land within the meaning of Section 1225B2C. And the government's view is...
If you can finish the sentence, I have a question.
So the government's view is that decision is controlling on this issue?
Well, now I have another question. Your argument is that a BIA opinion is controlling on the D.C. Circuit? I'm new here, but...
So the government's view, Your Honor, is that the BIA's opinion is entitled to Chevron deference, and that comes both from the INA and, as the Supreme Court noted in INS versus Aguirre, the fact that the INA specifically makes clear that the Attorney General's rulings on questions of law are controlling, and the Attorney General has the authority to delegate that power to the BIA.
Okay, let me ask the question I was going to ask. The same question I asked to Mr. Sheldon. Do you know how long Mr. Cruz was in the United States, time-wise? Seconds, minutes, hours?
So there's not a specific record finding on that point, Your Honor. Page 116 of the appendix is the closest the district court came, I believe. The district court concluded, based on Mr. Cruz's sworn statement, that after crossing the border, he immediately surrendered to immigration agents. My understanding is he crossed the border illegally in the middle of the night on May 10th, and it appears to be that within a matter of hours surrendered himself to immigration agents, but there is no specific finding on this point.
Well, hang on.
Do you have a theory?
I'm sorry, but I just say the form I-213 gives the dates and the time that was submitted by Mr. Sheldon. It gives and it's actually arrived one day and detained the next day because it was late at night. But it gives the exact dates and times. So I don't know how you say it's not in the record.
Yes, Your Honor, I was just
mm-hmm.
Yeah, I was just referring to the record before the district court. The I-213 form, I believe, was submitted as part of a judicial notice motion after a proceeding.
The government's form. You don't dispute. Do you dispute the form? You don't think we can take notice of it?
The government does not dispute that form, Your Honor.
Okay. We have dates and times.
Yeah,
it looks like it's about 90 minutes.
That's Your Honor.
And it crossed over from one day to the next day.
Yes, that's the government's understanding as well. The only reason...
Yeah, it's a decision that talked about entry the same day. The same day. We only have a BIA decision that says the same entry and detention on the same day. And with, I think there it might have been 30 yards. It's still an entry. But that's not this case.
So the government's view, Your Honor, is that the facts are substantially similar and that the BIA's opinion did not depend on the physical distance the alien had traveled, but rather on the statutory text and the fact that accepting the proposition that Mr. Cruz advances that an alien ceases to be arriving the moment 1 foot touches United States soil would render the phrase whether or not at a designated port of arrival completely inoperative. And the government's view...
Well, I get that, but we're not talking about 1 foot. And my recollection is, sorry, I think, is that MDCV? I can't remember. That talked about arriving the same day. And this was way more than one. This was 3 football fields. This was more than 1 foot in. So I don't know where we have, when do we get a reasoned interpretation from the BIA on when do you stop arriving and you're arrived?
So, Your Honor, I would point primarily to page 23 of the BIA's opinion, where the BIA notes that its reasoning is applicable to aliens apprehended near the border or just inside the border. And the government understands those are qualitative descriptions. But given the nature of the inquiry, there will not be a fixed bright-line rule. But the government respectfully submits that this is not a case that implicates the outer limits of that definition. And as a practical matter, the MPP guiding principles generally provide that an alien is amenable to being returned under MPP if he or she is encountered within 96 hours of crossing the border.
Sorry,
go
ahead, Mayor.
On the Chevron question, do you know of any cases where a government agency which has been litigating a question for several years and almost immediately before oral argument in a related case issues a Chevron interpretation and the court accepts that as controlling. I understand the argument that the BIA in general would have this, but we have to at least consider the context here, which is that BIA certainly knows what's going on here, and that if it's the case that it can't in the course of litigation interpret Chevron, then get a Chevron deference for an interpretation. Why should it be able to get it when it issues an adjudication right before an oral argument?
So, Your Honor, I'm not aware of any case that specifically mirrors the facts you just mentioned. The government's view is that the BIA's decision is entitled to Chevron deference because it echoes DHS's interpretation of Section 1225B2C. And as for the specific timing of this decision, I'm not aware of any considerations that have informed that. But again, just based on the structure of the INA and the fact that the Attorney General's rulings on questions of law are controlling, the government would submit that Chevron deference is appropriate here.
What text is, I'm sorry, Judge Millett.
No, go ahead.
What text is ambiguous? What text in this 1225 statute has sufficient ambiguity that you think it should trigger Chevron deference?
So, Your Honor, the government's view is that if this court concludes that the term arriving is ambiguous, then Chevron deference should be triggered and the BIA's decision should be entitled to wait.
Okay.
Did you say 96 hours is the rule?
It's the general principle, Your Honor.
Where's that general principle?
So that particular document is not part of the record below. I'm happy to proffer it to the court if the court believes it would be useful.
What kind of document? Sorry, I don't know what it is. Is this a regulation, a policy statement, a handbook? Where does 96 hours come from?
It's a guiding principles document, so it's an operational document that DHS has issued to its Border Patrol agents to effectuate the statutory authority in Section 1225B2C. You
don't claim any deference to that, though?
No, Your Honor. That's merely for additional context and to dispel any concerns about hypotheticals of aliens who have been here far longer than 96 hours being returned under MPP. And again, I'm happy to submit that to the court if the court requests it. It was not submitted below largely because the arriving claim was not raised until oral argument before the district court.
And I think maybe it is there. I think maybe page 11 of the appendix is U.S. Customs Border Protection, Migrant Protection Protocols, Guiding Principles.
Yes, Your Honor. I'm referring to a different document. Those outline the general principles applicable to MPP writ large. The document that I'm discussing hones in on this specific issue when Border Patrol agents consider aliens to be arriving on land for the purposes of Section 1225B2C.
So the MPP protocols and guidance don't reference 96 hours?
The specific guiding principles that are currently in the appendix do not refer to that limit. No.
Are there other MPP guidance or principles that do reference 96 hours?
Aside from the document I just mentioned, I'm not aware of any other documents.
Okay.
I know that my time has long since elapsed, but I would like to briefly address the non-refoulement claim. So the district court correctly concluded that Section 1252A2B2 bars judicial review of this claim. And as an initial matter, Mr. Cruz does not address that holding in his opening brief, so it's the government's view that he's waived any arguments he might be able to advance on this issue. But in any event, the government submits that the district court's holding was substantively correct and consistent with this court's precedent. Section 1225B2C provides that the Secretary may return aliens provided that they are statutorily eligible and that no other provision of the INA constrains that authority in any way. In other words, Section 1225B2C bears both hallmarks that this court attached substantial importance to in Zhu versus Gonzalez in considering the national interest waiver statute. I'll
just back up and ask one more time. C talks about in the case of an alien described in subparagraph A, and then subparagraph A begins subject to paragraphs B and C. And just to be clear, so your definition, you don't read that subject to paragraphs B and C as someone who's described in B. You just mean it as someone who hasn't been treated under B, just to be clear, right? That's what you mean, subject to paragraphs B and C in 2A, sorry. I just want to know what subject to means.
Right. So the government's view is that Section 1225B1 does not apply to Mr. Cruz because he was not placed in expedited removal proceedings.
And so he's not covered by subject to paragraph B. Got it. So subject to is not a statutory reference. It's a reference to prosecutorial discretion judgment.
In the case of Section 1225B2B2, yes, Your Honor. And again, the government will refer back to matter of ERM and LRM proposition.
Sorry, I interrupted you.
Can you just tell me again the non-reviewability provision that you're talking about?
Yes, Your Honor. Section 1252A2B2.
Okay, can I ask, you have I think you have a very brief reference to another provision. We're talking about refoulement now, right?
Yes, Your Honor, the district court's disposition of the non-refoulement claim.
Right, so, and that's 1231, right? That would be the statute that would be relevant, is that right?
The government's view is that Section 1231 does not apply in this case because Section 1231 concerns removal, which is a different context than contiguous territory return.
So my question is that in your brief, you briefly mention 1231H, H, which says nothing in this section shall be construed to create any substantive or procedural right or benefit that's legally enforceable by any party against the United States. There's just a briefest mention of, I think it's in your brief, it's in somebody's brief. Why is this not the section that you would be relying on for non-reviewability? No cause of action, put it that way. Sorry.
The government certainly has no objection to this court.
I know, but there must be some reason I'm missing. I don't want to make a mistake here. What's the reason that this section isn't relevant?
So this largely just stems from the court's order of operations in June. In June, this court concluded that Section 1252A2B2 barred judicial review, and then it had no need to consider whether, for example, the agency discretion by law exception to the APA applied. So in the government's treatment of the issues in the order of operations in our brief, we similarly viewed Section 1252A2B2 as a threshold jurisdictional issue, and then the lack of a cause of action as an alternative argument.
All right. If you're wrong about the discretionary question and therefore the jurisdictional question, would this apply or not apply? Would H apply or not apply? Isn't there the petitioner's argument is under this section, right? That they argue 1231 should apply.
Yes, Your Honor.
And then we have a statutory provision that's that very section that says nothing in this section shall be construed to create any right.
Yes, Your Honor.
I'm not trying to make your case for you. I have some feeling that I'm missing some reason. That's not usual that the government buries its best argument in one sentence and then doesn't make it. So I just feel like I'm missing something here.
So again, Your Honor, we have no objection to this court concluding that there is no cause of action here. Because the treaty obligations are not self-executing, there is no domestic statute that is applicable. Again, the reason the government ordered the issues the way it did in its brief is because we viewed the injunction that Mr. Cruz sought as clearly triggering Section 1252A2B2 because he asks this court to set aside the discretionary decision to return him to Mexico, and moreover, that is also the ground the district court below ruled on. And for those reasons, we led with our Section 1252A2B2 argument, but we would certainly have no objection to this court concluding that there is no cause of action or mechanism to challenge the implementation.
Did you argue that? Did you argue that in your brief?
We did mention 1231H.
You mentioned it. That's not the same thing as, did you make an argument that there's no cause of action here?
The government did assert that because the treaty obligations are not self-executing, that there is essentially no mechanism for Mr. Cruz to challenge the non-refoulement obligations at issue here.
You just have this one line here. It's just this one line, and there's no argument. There's no citations. There's nothing here. Is that sufficient to raise an argument?
So again, Your Honor, that line concerns Section 1231H, but the government believes the preceding paragraph also builds on that argument, and in any event would also submit that the Section 1252A2B2 bar applies here as well. And finally, just to conclude, in the government's view, the Supreme Court's recent decision in DHS versus the Regents of the University of California decision, that decision forecloses Mr. Cruz's equal protection claim because, like the litigants there, Mr. Cruz relies on a number of statements made by the president, remote in time and unrelated to MPP, and for that reason, he has not made out a plausible equal protection claim. And then finally...
I'm sorry, I apologize. I just wanted to hop back to the the guidance and principles issued by the Secretary of DHS were specific and explicit that protections under Convention Against Torture and non-refoulement protections would continue to apply. Is that right?
Yes, Your Honor. In promulgating MPP, DHS made clear that it would abide by all relevant non-refoulement obligations.
Does that create any right then if you don't?
So, Your Honor, the only situation in which the government believes it would create such a right is if, for example, the claim was that the agency failed to abide by the prescribed non-refoulement procedures. But importantly, that is not the claim here. Mr. Cruz was afforded a non-refoulement interview
but long after he'd been returned and then brought back in. And even when he was finally given one, it's not clear that he was told he could have counsel. There was no immigration judge review.
So let me address both aspects you just mentioned as to why he was returned initially without receiving a non-refoulement interview. That is because the agency made the choice that in the context presented by contiguous territory return, the onus is on the alien to articulate a fear of return. And importantly, Section 1225B1A1 also notes that similarly, for the credible fear process to be triggered, an alien has to indicate an intention to apply for asylum or a fear of persecution.
The Secretary was explicit that existing non-refoulement procedures and protections would be retained. Did not say that we would change those in a way. It's not ordinarily required that is it ordinarily required that they raise the issue first, or is that normally outside this context? Is that something that's asked by immigration officers or immigration judges even?
So I'm not sure I fully understand your question. Is it about
shifting the burden? Sorry, so shifting the burden to the immigrant to spontaneously raise concerns about covered by non-refoulement, concerns about torture or mistreatment in the place to which they're being returned. Is that the normal practice under 1229A procedures?
So the only reason I'm hesitating to answer your question is credible fear interviews only occur in the course of expedited removal proceedings under Section 1225B1. After the alien expresses an intention to apply for asylum or a fear of persecution, then the immigration officer asks the alien discrete questions. But importantly, the context here is fundamentally different.
Okay, so under 12, let me be clear, under 1231, right, restriction on removal to a country where an alien's life or freedom would be threatened. If you're applying that process, put aside MPP. If you're applying that process ordinarily, my understanding is that the burden is not on the individual alien to first raise that question without notice, without counsel, so they just have to spontaneously raise that. Is that true?
In the context of full removal proceedings, I believe that's correct, Your Honor.
Okay, so then...
But again...
Sorry. Go ahead.
Yeah, so just to reinforce the point I just mentioned, the context here is fundamentally different. And importantly, an alien can express a fear of returning to Mexico at any point during the time that his removal application or removal proceedings are pending in the United States. So an alien can have multiple non-refoulement interviews, and indeed some aliens have had multiple non-refoulement interviews.
No, but I'm just going back to when if the MPP protocol has said we're going to continue to adhere to non-refoulement obligations and practices, then changing this whole process, the burden of raising the issue, the level of proof by which they have to raise it, the lack of notice, that's all different, isn't it? That is a change.
So it is a change, Your Honor, but the government, again, believes that the context here is different, that it's not a departure from previously existing policies that were applicable in an analogous context. So the considerations applicable to contiguous territory return of an alien to a country that he or she transited through, those considerations are fundamentally different than the considerations of returning an alien to the home country where they may face persecution. And the government's view is the agency was entitled.
Well, then why did the guidance say we'll treat them the same?
So the MPP guiding principles simply discuss non-refoulement generally and the principles of non-refoulement. And in the USCIS memo applicable to non-refoulement interviews, USCIS is clear that the withholding of removal regulations are inapplicable because, again, these are not removal proceedings.
But then how can it be so that your position that the Refugee Act and the Convention allow return if someone actually they didn't know to raise it, they just didn't know they could raise it, but they actually were in fear of being harmed in Mexico. Your view is that you're not obliged to apply that for a contiguous territory return?
So that's view. The government's view is not that it does not have to abide by non-refoulement obligations, but rather that nothing in Section 1231 or either of the treaties you just mentioned prescribes any minimum procedures that the executive branch has to adopt to comply with its non-refoulement obligations, and accordingly, the executive branch was entitled to rely on the different context presented here to fashion different non-refoulement procedures. And I would also refer this court to Section 1231B3A, which notes that it is for the Attorney General to determine if an alien's life would be threatened based on a protected ground. So no part of Section 1231 prescribes a minimum set of procedures that the executive branch has to follow. And so the government's view is that the procedures here are fully adequate to satisfy all relevant obligations.
And the procedure would be adequate even in a full 1231 removal proceeding.
But again, Your Honor, the government's view is that context is fundamentally different.
You just told me all you're obligated to do under the Refugee Act and the Convention, all you're obligated to do is what you've done here. Is that true or not?
Yes, Your Honor, that's true.
So you could do this exact same process in withholding removal. You've just been extra generous so far.
So the government's view is, again, taking into account the considerations unique to removal of an alien to a country where they may be facing persecution or torture and where they may have no other opportunity to raise a claim of fear, the procedures fashioned are different. And I would also point this court to the Supreme Court's decision in Duricidium, where in pertinent part the Supreme Court discussed the abuses of the credible fear process, the fact that there's been almost a 2,000% increase in credible fear claims, which have in turn exacerbated the existing burdens on the immigration system. And so given those burden concerns, the government's view the agency was entitled to rely on the specific context presented here to fashion non-refoulement procedures.
Okay. Is there some place where the DHS explains what all this rationale that they must think there's a reduced risk of torture or mistreatment in a country to which you're returned rather than removed? Where is this explanation for change in policy? At least you just described it as it's a different country, but it's clear that non-refoulement applies to third countries as well. So where have they explained why the risk is lower?
So in the October 20th, 2019 assessment of the migrant protection protocols, DHS explained that based on its experience administering.
I'm sorry, I didn't hear it. Which memo? Which state?
So it's not a memo in the appendix. It's a publicly available assessment of MPP that the government relied on below. And again, I can also submit this document if the court believes it would be helpful. But in that document, DHS explained its view that based on the agency's experience in administering credible fear interviews, its view was that if it altered non-refoulement procedures in the manner suggested by litigants like Mr. Cruz, the number of fear claims would become overwhelming and would lead to untenable burdens on the limited number of asylum officers there are. And again, based on the Supreme Court's decision at Thursigium, that concern is not purely conjectural.
Well, I don't understand. Is burden, that nothing in what you just said that they were improper or not credible fear claims. Is the agency able to establish a standard that rejects these claims simply because accepting them would be too burdensome? Is that consistent with the treaty and the statute?
No, Your Honor. So the government's view is that in the credible fear context, for example, in Thursigium, the Supreme Court noted that of the large volume of credible fear claims that are made, many turn out to be meritless, and more importantly, many turn out to be abandoned, and litigants and aliens simply abscond into the interior of the country. And the government's view is just given that concern.
But that's not an issue here. There's no risk of absconding into the middle of the country in that sense. We're just talking about having the interview here and deciding whether return versus detention is warranted. So I don't know. Maybe there are a lot that end up not to have merit. Aren't there a lot that also do have merit?
So it would not be possible for me to quantify the number of claims that would have merit and the number of claims that would not have merit. The government's view is something that the agency acted reasonably in relying on that concern and its experiences administering credible fear interviews to fashion the procedures that it did. And again, Mr. Cruz did receive a non-refoulement interview after he came back to the United States for his July 30th hearing. And during that hearing, he was afforded an interpreter. The interview occurred in a non-adversarial setting, and the results of the interview were subject to supervisory asylum officer review.
Counselor,
I don't mean to cut you off, but just say that the document you referenced that you said isn't before us from DHS, I would like to, if it's okay with my colleagues, I would like to have that submitted.
Understood, Your Honor. I will submit that.
Sorry, Judge Walker.
The worst version of what you've just described, I'm going to describe. And then I want you to tell me, if you would, why that's not actually what happened. There are tons of border crossings and asylum claims. And as you said, they're up 2,000%, or at least they were. And that's an administrative burden. One way to avoid that administrative burden for asylum seekers is to just not ask them if they're seeking asylum. The guidance from the Secretary says a third country national should not be involuntarily returned to Mexico if the alien would more likely than not be persecuted on certain reasons or would more likely than not be tortured. If you ask everybody, that you're going to return to Mexico while they're waiting on their asylum claims, if you ask everybody, are you more likely than not to be persecuted and are you more likely than not to be tortured, you're going to get more yeses than you would if you just don't ask the question, because there will be some number of people who just don't know that they're supposed to tell you. They're afraid that returning to Mexico will lead to either their persecution or their torture. And that's a good thing, you say, from DHS's perspective, because it's less of a burden on DHS if we just bury our head in the sand here. Is that the reason? Is that really the reason that DHS has decided not to ask people they're returning to Mexico if they're more likely than not to be persecuted or tortured? or is there a different reason?
So the missing component of your question, Judge Walker, that I would just point to is that returning to the credible fear process for a second, in Thursday in the Supreme Court, that not only was there a massive increase in the number of credible fear claims, but many of them turned out to be completely meritless and were abandoned. And so the government would just point to that and state that based on that experience with a number of credible fear claims that turned out to ultimately be devoid of any merit, DHS fashioned different procedures in this context and was entitled to do so.
And so DHS made a policy decision exercising their discretion that in order to avoid the burden of a lot of frivolous claims, they would adopt a policy that is guaranteed to not catch some number of meritorious claims.
So the government would resist that characterization simply because a number of aliens have articulated a fear of returning to Mexico, like Mr. Cruz. And again, Section 1225B1A1, even in the credible fear context, provides that a credible fear interview doesn't occur until an alien first expresses an intention to apply for asylum or a fear of persecution. And so in the government's view, this situation is not meaningfully different from that statutory commands.
Okay.
It's more likely than not different than credible fear.
The more likely than not standard is what is ultimately used to determine whether an alien has credible fear. Yes, Your Honor.
But I'm sorry, I wasn't clear. An expedited removal to get to an asylum hearing, do they have to show more likely than not, or just to get to the hearing, do they just have to assert a credible fear?
Yes,
is credible fear more likely than not, or is it plausible, substantial?
It's a reasonable probability. That's my understanding. That's the burden at the credible fear stage.
So for expedited removal, if your prosecutorial discretion had left him there, he would have to just show a reasonable probability. But because you processed him under 1229A and subject him to return to Mexico, he has to show more likely than not. Yes, is that right?
Yes, Your Honor. And again, another important difference between this case and credible fear claims I would point to is the fact that aliens do not receive more than one credible fear interview, whereas aliens can and do, in fact, receive more than one non-refoulement interview because they can articulate a fear of returning to Mexico at any point while their removal proceedings are pending in the United States. And just to very brief.
All right, I think it's too late to be very brief. I think we have your arguments, and to the extent we don't, we had them in the briefs. I'm going to let Mr. Sheldon have 2 minutes. And thank you very much for your argument.
Thank you. Okay, just briefly, I'd like to get to more likely than not, it's completely different than credible fear.
Mr. Sheldon, we're having trouble hearing. Maybe you need to speak more directly into the microphone.
Can you hear me now, Your Honor?
Yeah.
Okay, thank you. So more likely than not, it's completely different than credible fear. Credible fear is set out in B1 in details, extremely low standard. More likely than not, you have to prove, beyond whatever, beyond more 50% that you will be persecuted. It's extremely hard standard for someone to meet without evidence, without a lawyer, without any type of procedure. I mean, it's virtually designed so there's no chance on earth that they're going to pass. The government claims they don't have money, that it's too much of a burden. I mean, CBP and ICE have a budget of $19 billion. The entire EOIR is $350 million. I mean, the cost of them doing hearings is negligible compared to their cost of, detaining 60,000 people a year that could, cost the same as sending them to college for a year. Again, back to Judge Millett, I mean, never before in history has there been a procedure where you have to ask, in the U.S., where you have to ask the government and tell them you're afraid. I mean, this is a completely new standard. And we would analogize it to asking a detained person, a prisoner, to ask for water, instead of being given water. It's a completely new and a completely arbitrary and reasonable standard. Okay, so 1231, I mean, if just read it quickly. I mean, it says the Attorney General may not remove an alien to a country if the Attorney General decides the alien's life or freedom would be threatened. I mean, it says may not, and it doesn't say any specific country. It says any country. The Chevron deference, you know, I
ask you, what do we do with this sort of no cause of action kind of language?
Oh, Your Honor, I mean, okay, there's a presumption in favor of judicial review.
This is not a question of review. It's not a jurisdiction. It's a question of the cause of action. What do I do with that language?
Again, the government didn't bring it up previously. It's kind of
the government does have a sentence, and I didn't think of it myself. I'm sure I would never have thought of it myself because the statute's awfully complicated, but it is included in the government's argument. What do you know anything about it? If you don't, I understand it's because you.
Yeah, I don't know, but it just, I mean, clearly the Constitution, the statutes, all that takes great precedence over one little line where they say, you know, that you don't have an individual right. I mean, I think what they're referring to would be a litigation or a lawsuit where you're asking for damages. I mean, I don't think they're talking about the constitutional rights or the statutory rights of 65,000 people, including 16,000 children that have been sent to another country. I don't think that's what Congress meant at all.
But you didn't sue under 1231H, you sued under the APA, correct?
That's exactly correct, Your Honor. We're not even talking about immigration. This case really has nothing to do with the immigration statutes, with removal. I mean, our client has not been removed. We're not even discussing that. We're talking about whether the government can grab people with armed police and throw them into Mexico while they're awaiting the hearing. This would be analogous.
Is there any question in your experience as an immigration lawyer that the CAT protections that are in 1231 may be raised on at least review of a final order of removal? First of all, it's withholding of removal claims. The CAT would be a separate provision, but no, I mean, absolutely 100%. This case could never be reviewed on a question of removal in the Court of Appeals for the removal case. It has nothing to do with the removal case. I mean, if I even brought it up, it would be utterly irrelevant. I mean, the only question they're going to look at is his removal. Did he get a fair procedure in his removal case? This has nothing to do with it. I mean, except for the fact, of course, that only, you know, maybe we could argue that only 22 cases have apparently been approved out of 11,000 cases, you know, that have been decided in the MPP context because people don't have lawyers. They don't have any type of, they don't even know they have hearings.
Okay. Mr. Sheldon, who grabbed him?
He turned himself in. I mean, he was.
That's what I thought. But you said a moment ago he was grabbed by armed people.
Well, I mean, grabbed and thrown out of the country. I mean, he was woken up one morning. He thought he was going to be, you know, he thought he was going to be placed in proceeding in the States as everybody else has for the last, you know, forever. And then he was just grabbed and put handcuffs on and thrown into Mexico without, you know, literally without any, you know, he says in his statement, he says this wasn't a question, it was an order. It's sent out of the country.
What do we do with the case Omar v. McHugh? The government briefed it pretty extensively, and I don't think you mentioned it in your reply. It says that it's a D.C. Circuit case that says when it comes to the question of whether or not a foreign country is going to torture somebody we're sending there, judges don't decide that. That's a decision completely in the executive.
Right, Your Honor. That's completely, again, a lot of government smoke here, trying to distract the court.
I'm not asking about the government's argument. I'm asking about the D.C. Circuit finding precedent, Omar v. McHugh.
Those cases are about extradition. They have nothing to do with this case. I mean, when you have an extradition treaty with another country, you know, that supersedes anything else. I mean, if the United States signs a treaty with England and we're returning a criminal, okay, then they can't start bringing up what's going to happen in England. That's not what we're talking about here, Your Honor. There's no treaty. I mean, this is asylum. It's completely different law.
You're seeking prospective relief, and when it comes to the refoulement question, let me rephrase. Assume that I think at this point, Mr. Cruz has received all of the refoulement process he's entitled to, and that his refoulement claim has been adjudicated by Homeland Security in an appropriate manner. I know you don't think that, but assume I think that. You're seeking prospective relief. Even if I were to agree with you that he should have gotten the interview earlier, What do I do with that? What can the court do with that?
Okay, I mean, there's four different ways or something we can win in this case. I mean, the statutory argument on the MPP, the statutory argument on the alien, whether he's in the United States. I mean, that's just one of our arguments is the international withholding of removal, Your Honor.
Okay, I'm good.
I mean, obviously, we think
Mr. Sheldon, if you could just wrap it up in a sentence or two, that would be helpful.
Oh my gosh, I'd like to just talk quickly about the Chevron deference. I mean, I just want to mention there is an agency regulation. And if the government, the court's going to give Chevron deference to anything, it should be this regulation that's existed since the statute was put in, and it interprets the contiguous territory provision. It limits it to arrivals at the port of entry. So, that should actually take precedence over a matter of MD.
Just cite that regulation for us.
It's 8 CFR. It's the regulation interpreting
I'm sorry.
It's 8 CFR 1235.3D.
Thank you.
And it clearly says that it's only supposed to be applied to aliens arriving at a land border port of entry. In other words, even if the government, when writing the regulations, didn't think it applied to people of the United States. Irreparable harm. I mean, I do want to mention one thing. There's Gordon V. Holder from this court and also Millett v. District of Columbia say if a prospective violation of a constitutional right constitutes irreparable injury, we think this is a constitutional violation. So that would take care of the injury, the irreparable harm. But, in addition, Mr. Cruz was sent to one of the most violent places on earth, an area controlled by the Juarez drug cartel, not the Mexican police. He's living in daily terror. He's afraid he could be sent back to Guatemala by the Mexican government. He's afraid that he could be killed by the same people that are after him from Guatemala. They could find him in Mexico. I mean, to say that there's no irreparable harm, I mean, I would analogize this, to the 1939, the boat St. Louis arrived off the Florida coast and they sent it back. I mean, he's also subject to obviously badly malfunctioning asylum hearing system, where 22 cases have been approved out of 11,208 that were ordered removed. I mean, clearly he has irreparable harm. The jurisdiction, I mean, this case is, because it's not about removal, it's not about immigration, it has nothing to do with discretion. Because, under Zadvitas and other cases, the court said the authority is not discretion. The agency's authority is not discretionary. Just to wrap up, Your Honor, I just want to, a few blocks from the courthouse, there's a monument to the Japanese Americans during World War II held. The Japanese Americans who were detained in World War II held to be legal by the Supreme Court in Korematsu. There are quotes from President Reagan, senators, others apologizing, saying this must never happen again. Yet today the government is violating the law and the Constitution to send women and children seeking asylum in our country into extreme danger. It may not be popular, but this court should order the government to follow the law. I have a few other, I don't know if there's more questions. I have a few other things I wanted to say, but I realize I'm out of time.
All right. Thank you, Mr. Sheldon.
Thank you very much, Your Honor.
Thanks to both counsel. We'll take the matter under submission.
Thank you very much, Your Honor.
This honorable court is now adjourned until Wednesday, February 16th at 9:30 a.m.
Goodbye.